to speak for or oppose the bill, proponents and opponents, to do so. Again, I ask you to be mindful of the number of people that we have who wish to talk to the bill, and for that reason, I will not hopefully be rude to you, but I may say time's getting to be important, and please conclude your remarks if you're going too long. We always start out with the presenter of the bill. In this case, we have Senator McCune, who is here as the author of the sponsor of the bill. And Senator McCune, we're glad to have you. I think you and I have had several discussions about this particular legislation. And the process we're going through is to have public input today. This subcommittee will meet again, expecting to do so tomorrow. And depending on what happens from that subcommittee meeting tomorrow, we expect to have the bill go to full committee on Thursday. I know you've got a lot of bills from our committee and others before your committee, and I would urge that, I know you talk about having some hearing this afternoon, right, at 4 o'clock, so we want to let you get through that so you can have those bills considered and hopefully pass them out for consideration to the full Senate. With that, I'm going to allow Senator McCune, if you would please, speak to Senate Bill 129.
Thank you, Mr. Chairman, and thank you for the opportunity to be here today to discuss Senate Bill 129. What I would like to do is...
Let me ask you to pull that mic right there. The other one is the TV or reporter's mic, I believe. That's right. Better. Thank you.
Thank you, Mr. Chairman. So what I'd like to do is just go through a little bit of the history and then go through the bill itself. And then I would like to sort of anticipate some of the objections that you might hear and give some information on those.
Sure.
The history behind this piece of legislation really goes back to a Supreme Court case, Sherbert versus Verner in 1963, which established as a matter of law the compelling interest test to be utilized to determine free exercise claims. And basically, it sets up a balancing test. And the balancing test is that the government may have a rule or an act or a law that substantially burdens a person's exercise of religion only if it can demonstrate that the application of that burden is in furtherance of a compelling governmental interest and it's the least restrictive means of achieving that interest. That case controlled not just at the federal but the state level as well from 1963 until 1990. In 1990, there was another Supreme Court case, Employment Division versus Smith, which eliminated the compelling interest test. And Congress reacted to that, one of the few times really in American history that has occurred, and they passed the Religious Freedom Restoration Act in 1993. It was passed unanimously in the United States House of Representatives. It was passed by a vote of 97-3 in the United States Senate and signed into law by President Bill Clinton. So you may then ask, why am I here with a Senate bill if we've got a federal law on this subject? And the answer to that question may be found in a 1997 Supreme Court case, a City of Bern v. Flores. And in that case, the Supreme Court held that while the Religious Freedom Restoration Act could be used to restrain federal government actions that interfered or substantially burdened a religious liberty interest, that Congress could not mandate that balancing test for state and local government action. And so since 1997, 31 states, either by legislative act or by court decision, restored the compelling interest test. And I believe before the week is over, it'll be 32, with Indiana adopting a bill that is almost identical to the bill before this committee today. So that's sort of the procedural history. What I'd like to do now is just briefly go through the bill itself. What we've tried to do with the bill language is as closely as possible mirror federal law. Last year, the Senate Bill 377 that I had and the House proposal that was sort of mirrored it, neither of them exactly mirrored the federal law. And the feedback we heard towards the end of the legislative session and over the interim was what you really need to do as a safe harbor is stick to the federal language, because the federal language has 22 years of case history. It's predictable. We know what courts will do with it. And so that's what we've tried to do. Section 1 is just the name of the act. Section 2 creates a Chapter 15A. And the first section from lines 14 to 23 begins a series of legislative findings. These findings are taken almost verbatim from the Federal Religious Freedom Restoration Act. You'll see at lines 18 and 19 a reference to the Georgia Constitution. That's obviously not in the federal act. If you move over to page 2, you will see additional findings. We added finding 6 from lines 30 to 33, which simply recites the City of Bern case that I went over earlier, just to explain why this act is necessary. And then, obviously, there's been a lot of discussion, and I'll return to this in a moment, about discrimination and the possibility of this act being used to facilitate discrimination of some kind. And so we actually took I believe, the extraordinary step of adding as a legislative finding of fact that courts have held that government has a fundamental overriding interest in eradicating discrimination. I think the findings pretty much speak for themselves. I mean, the first one talks about the history of free exercise. The second talking about the fact that laws that are at least on their face neutral toward religion can burden religious exercise. And the third, that government shouldn't substantially burden religious exercise. In the fourth finding, we recite Employment Division versus Smith. In the fifth finding, we simply point out that the compelling interest test has been a workable test for striking that balance between religious liberty and competing prior governmental interests. And then I mentioned 6 and 7. So then we move from the findings to the purpose section from lines 36 to 41. This is verbatim from the federal law, and it makes it clear that what we're intending to do is to restore the compelling interest test as set forth in that prior line of cases that I mentioned earlier, and to guarantee that that compelling interest test will be applied in all cases where free exercise of religion is substantially burdened. And then the second purpose is to provide a claim or defense to persons whose religious exercise is substantially burdened by government. Now then we move on to the operative language at lines 42 to 52, and this simply codifies the compelling governmental interest test. It makes it clear that government may substantially burden a person's exercise of religion if it may demonstrate that the application of that burden is in furtherance of a compelling governmental interest, and it is the least restrictive means of achieving that compelling governmental interest. We also add that a person whose religious exercise has been burdened in violation of this chapter may assert that violation as a claim or defense in a judicial proceeding and obtain appropriate relief. Then at lines 53 through 56, we truncated a little bit, but it is essentially the same, that the party who brings an action under this chapter the court may allow a reasonable attorney's fee to be awarded as part of cost. Then at page 3, lines 57 to 62, that is language that was later adopted federal language, and that was to make sure that when applying this act to a corrections environment, to a prison environment, that there's an appropriate balancing there of the specific needs of the prison to maintain good order and discipline. We added at the request of the business community lines 63 and 64, that is new language, to make it clear that nothing in the bill would be construed to create any rights by an employee against an employer if such employer is not government. This is something that is strictly dealing with the government and its impact on a person. At lines 65 through 90, we have a series of definitions. Delinquent act and delinquent act, penal institution, and restrictive custody are all definitions that you wouldn't find in the original Federal Religious Freedom Restoration Act. They're added here to apply to the language at lines 59 through 62 for the prison environment, and these were at the request of the Department of Corrections and the Department of Juvenile Justice. The definition of demonstrates is out of the federal act. The definition of exercise of religion is out of the Federal Act, again, with the exception that we refer not just to the federal Constitution, but to the state Constitution as well. The definition of government is also taken directly from the Federal Act. And then page 4 simply has the normal effective date language and the repealer. There are a couple of issues I'd like to take the opportunity to address just in anticipation of some of the objections I think that the committee may hear. And I'll try to be brief. I want to be respectful of the time of this committee and of those that wish to also be heard. One thing that has been said an awful lot in the debate about this legislation is that this is a solution in search of a problem, that we don't really have an issue in Georgia. And the fact of the matter is we've documented a number of cases. I will not read through all of these. I can certainly provide the committee with copies, but I'll mention a few. There was an individual who repeatedly requested officials with the Atlanta public school system for permission to begin a religious student club at Sutton Middle School. The district allows many other student clubs to meet before, during, and after school without charge and have access to certain benefits and privileges in terms of publicizing group activities to others. The district, based on so-called separation of church and state concerns, denied the request for equal treatment and insisted on treating the club as a community organization that must rent school facilities. At Savannah State University, administrators revoked official recognition for a Christian student club due to alleged hazing violations. According to administrators, this hazing occurred when the ministry held a foot washing ceremony in a discipleship retreat. Such a ceremony follows the example of Christ, who washed the feet of his disciples, and an example of service, love, and humility. This resulted in the students' group's complete loss of access to the campus for any facilities. There are about 12 other examples I could mention that we have documented, and I just share those with you to make it clear that this is not a hypothetical or an abstraction. This is something that's very real, and it's affecting Georgians today. You will hear from some opponents when we talk about some of these examples, they will say, well, at some point the complaint was resolved. And what I would say to that is, in many of these examples, when the complaint was resolved, it was only after someone retained an attorney and spent years fighting a government bureaucracy for something that they are constitutionally entitled to. And adopting the Religious Freedom Restoration Act language will establish a bright line standard that will prevent this sort of government overreach from occurring, and it should actually reduce the number of these kind of cases that we see. But when we do see such a case, it will arm a person of faith with the right tools to be able to get a quick resolution to these sorts of concerns. The next thing that opponents of the legislation have said repeatedly is that the bill presents a so-called license to discriminate. And I want to be clear about this. The Senate Bill 129 would, like the federal counterpart, it does not provide any new rights to people of faith to refuse service to any person. And in fact, I'm sure you've seen the letter that was sent to me by Mr. Bowers. It's about a 6-page letter, I think. And there's not a case cited in any of the jurisdictions that have the Religious Freedom Restoration Act at the state level, nor are there any federal Religious Freedom Restoration Act cases cited where a court held that the Religious Freedom Restoration Act language shielded a discriminatory act. There simply is no evidence of that occurring anywhere where this law is already in place. The second objection that we've heard a little bit about is this notion that it's going to somehow excuse criminal behavior, that someone who believes, for example, that disciplining their child in a way that would violate our child abuse laws, that they would somehow be given a get-out-of-jail-free card by passage of this law. That's simply not true. There are no cases to substantiate that. And I think it's important to point out again that, opponents have characterized this bill as almost a way for a person of faith to press a button and get an exemption from a law. That is not how it works. It provides a balancing test for judges to apply to weigh that person's free exercise right against the common good, against the governmental interests. And I think judges have been able to handle that very well throughout the history at the federal level and in all the other state jurisdictions that have adopted the Religious Freedom Restoration Act. Finally, I wanted to speak to the discussion of a sort of a so-called civil rights amendment that might be added to this bill. And I think people point to Texas as an example of that. In fact, the Texas legislature this year, in both the House and the Senate, are considering constitutional amendments that don't have this language in it because of the number of unintended consequences that it has created. And I think when you pair that with the fact that the federal language has never been held by any court to justify discriminatory conduct, that anything we would do to move away from the safe harbor of the federal language creates uncertainty, it creates confusion, and frankly could lead to some unintended consequences. So with that, Mr. Chairman, that's my presentation of the bill, hopefully a brief summary of some of the arguments you might hear against it and my brief response to it.
Thank you. Could you go back for me, please? You mentioned a Texas amendment. What is that amendment claiming to do as far as a civil rights amendment?
There is when Texas adopted their Religious Freedom Restoration Act, they added some language saying that essentially there was an exemption to the Religious Freedom Restoration Act where certain application of civil rights laws were involved. And that, as I said, the Texas state legislature is now moving both the House and the Senate to adopt not a statute but a constitutional amendment providing for this compelling interest test, and they have deliberately chosen not to include that language because of the concerns that have been raised in litigation since the adoption of the statute.
All right, thank you. We do have questions of the members of the committee. Mr. Fleming.
Thank you, Senator, for bringing this bill. I know that you've put many hours of work into this, been attacked from all various corners for doing this. But I'll say that in the dozen or so years I've been associated with this legislature, in my opinion, this is the most important bill that I will ever vote on since I've been here. And the reason being is it goes to the fundamental reason this country was founded. People got on rickety wooden boats and crossed the ocean centuries ago just so they could come and have freedom of religion. And I think it goes to the founding of our nation, and I thank you for doing this. A couple of things I'd like to ask you about. Number one, you have in this bill on page 1 legislative findings. Now, I think that's important, but could you please express to the committee why it's important that we leave those legislative findings in this bill and not at any point take them out?
Well, thank you very much. The answer is, again, kind of goes back to the debate last year. We were told repeatedly by some who opposed the bill then and oppose the bill now that we needed to go to the federal language because the federal language was tested. The federal language had been in place now for 22 years. It was predictable. I think it's important, independent of that, because a court that is looking at the operative language, I think, will also look to the findings to make decisions, and that is why, frankly, with the concern about discrimination, that we added finding 7. And so I think it's important because it keeps us in line with the federal language, but I think independent of that, it's important because it provides additional guidance to courts that are going to be interpreting this moving forward.
The second question I have, it relates to something that you touched upon but did not mention specifically, and that is you talked about why this is relevant and why this is important. And I'd like for you to comment on, if you would, as far as importance is concerned, the fact that the federal RFRA was recently invoked by the Supreme Court when they decided the Hobby Lobby case. Could you comment on that?
Well, certainly. One of the issues last year that was in the debate is the definition of person and what does a person under this law mean. And the Green family, which owned Hobby Lobby, brought an action, obviously, against the administration, the Obama administration, over the mandate that would require them to pay for abortion-inducing drugs. And without the Religious Freedom Restoration Act, they most certainly would have been compelled, against their sincerely held religious belief, to be a party to something that they found completely abhorrent to their religious beliefs. And so it's something that's relevant today. It continues to be relevant. I think the litigation that we see in many local communities that are brought by outside groups to push policymakers towards policies that are hostile to people of faith, because there is no Religious Freedom Restoration Act. If you're sitting in that room as the lawyer advising a city council or a school board or a county commission, you're going to probably, as a safe harbor, push them towards a policy that's more hostile towards people of faith. And I think what this does is it rights the ship. It creates a balancing test that people can go and see how courts have interpreted in a number of jurisdictions, number of different cases, and be able to adopt policies at the local and at the state level that carry out the governmental interests that need to be carried out, but do so with a respect and accommodation for free exercise rights.
Thank you.
All right. Thank you. Mr. Bruce.
Senator, I'm trying to find a practical application for the bill. You talked a lot of lawyer stuff just now. And so I'm trying to find a practical application for the bill. And then I wanted to kind of share a conversation that I had with a physician and get your opinion on how the bill would be applicable. Okay? So can you first do that?
Sure. I mean, the cases I mentioned where you have a public school student who says, I want to be able to use school facilities to have this religious student club, that is clearly a case that would be governed by the Religious Freedom Restoration Act if we had it in place today. I didn't mention this, but there was a case in LJ where organizers of a prayer chain were informed they'd have to get a permit before being allowed to have a group of people assemble on a sidewalk for quiet prayer. And the organizers filed suit challenging the ordinance. The suit alleged that the permit scheme granted too much discretion to the person who issues the permit to engage in viewpoint discrimination. Well, again, that's the sort of thing that the policy that led to the lawsuit would have almost certainly been altered had the Religious Freedom Restoration Act been in place. The Savannah State University example I gave, where you have university administrators kicking a Christian student organization off of campus for holding a foot washing ceremony as part of a discipleship retreat. That clearly, it either would not have happened or it would have been very quickly rectified with the Religious Freedom Restoration Act in place. There are, like I said, a number of additional examples I can give you, but these are all real-world examples that have occurred in the state of Georgia that would be directly impacted by the passage of this legislation.
This is a follow-up to that. In both of those instances, would it still not possibly end up in court and a debate because there's still the question of separation of church and state? Even if we were to pass this legislation, there would still be the ability for people and the likelihood that people would challenge it on that basis, that it violates a federal law requiring the separation of church and state.
Well, I'm glad you asked that question. I printed out and brought with me here this document in celebration of Religious Freedom Day. It's back in January. It's put out by the current administration. And it actually has a section on the religious liberties of public school students. And the very first thing that's mentioned is students can pray, read their Bible or other religious books, and talk about their faith at school during school hours. And then it goes on to cite some regulations from the Department of Education. So clearly what this student at Sutton Middle School was asking for was less than that. And yet, again, because of what I believe is the murky system we are dealing with under the Smith decision, school administrators repeatedly denied that student what they're clearly entitled to. So if we go to the compelling interest test, I think that whoever is advising the school board is going to tell them as they develop policies to deal with people of faith that case won't happen. because they'll have a bright line standard to adopt policies around that will prevent them from intruding on the right of free exercise, as happened in that case.
Okay. Last piece to this. I want to provide a scenario and then have you respond to it, because this has come up, as you might imagine, we've gotten a gazillion phone calls.
I can imagine.
This. In the instance where someone is going into an establishment, wherever it is, and they've identified themselves as a customer, period. And the owner of that establishment concludes that this person's lifestyle, whatever it is that's going on with them, is inconsistent with their religious beliefs. Would this bill not, if this bill were to pass, would it not give the owner of that establishment the ability to say that based on my religious belief, I cannot or choose not to serve you?
No, it would not.
Okay. That is, I guess, where the challenge comes in. And, we can talk about it some more, but it appears that that's what the bill would do.
And I want to be very clear about this. There are 31 jurisdictions that have this bill in place. For example, the state of Illinois has had it in place since 1998. Federal government's had it in place since 1993. What you have just described has never occurred under the Religious Freedom Restoration Act. And I have no reason to believe that it would. I have no reason to believe that the plain language of the bill before you would empower a business owner to deny someone service. And I think to that point, actually, a lot of people, this controversy really got kicked off when there was a bill introduced in Arizona last year. The Arizona bill sought to amend their Religious Freedom Restoration Act, which had been in place since 1999. The amendment was designed to authorize denial of service based on religious beliefs. So what that tells me is that a lawyer advising that legislator said, well, if you want the Religious Freedom Restoration Act to do that, you're going to have to add language to it. And the Religious Freedom Restoration Act that Arizona's had in place since 1999 is the language that's before you today.
All right, thank you. Next, Mr. Weldon. No, I'm sorry. Judge, did you or somebody? Was Ms. Evans, pardon me.
Thank you, Mr. Chairman. Senator, you mentioned that the federal statute had not been successfully used as a defense to discrimination, but you are aware, however, aren't you, that folks have raised it as a defense in litigation, so that folks who felt they were discriminated against were forced to go through the litigation process to basically prove that they've been discriminated against and that the federal law did not protect that activity.
What I would say is that obviously, people raise lots of arguments in litigation, and there's a Supreme Court case from the 1980s of Bob Jones University versus United States, where explicitly the issue was raised of a religious defense to discriminatory conduct. And the IRS was threatening to remove their tax-exempt status, and the U.S. Supreme Court held that the government had a compelling state interest in that case to prevent that discrimination from occurring. So, again, I think that given the lengthy history that is before us and the total absence of any case where a court has decided in that way, I just, I don't see how we can legislate based on some sort of, I wouldn't even call it a remote possibility of something like that happening.
One other question, if I might, Mr. Chairman.
Yes, ma'am.
The definition of exercise of religion beginning on line 71 states that the exercise of religion means any exercise of religion, and then whether or not that's compelled by or central to a system of religious belief. So doesn't this allow each individual Georgian to decide what is or is not a religious practice on their own part, and for everyone to potentially have their own set of laws? And I realize that's extreme, but this is a very broad definition. Wouldn't you agree?
So let me. I think there are two questions there. The first question is, can people decide for themselves what their religious belief is? And I would say yes, that is most certainly the case. I think that if you're asking about how this law would then apply, it's not enough that someone have a particular religious belief that comes into conflict with a government rule. That religious belief has to overcome a compelling governmental interest. And so, again, I am certainly open if there are examples that can be identified where the language before the committee has been abused. I've been unable to find one.
Thank you.
All right. Ms. Oliver.
Senator, I've been involved over time in various religious protections of Jewish parents in autopsies of children, Christian scientists in relation to treatment of children, medical exemptions to vaccinations. I cannot find any reason that any of those protections in Georgia law have not been satisfactory, sufficient to protect families from not being able to carry out their own religious belief. Do you have any examples of any invasion of parents' authority over a child that has been violated based on state action in Georgia?
I don't know that I have an example in front of me that deals with that specific area. I think that the fact that we've documented numerous examples of the right of free exercise being trampled on by local governments and by university administrators and by school district administrators should be sufficient. I mean, the question that I would ask those that are opposed to Senate Bill 129 is, why should there be two separate legal standards? Why should there be one legal standard that applies when the federal government isn't interfering with the right of free exercise, and why should there be another much lower legal standard that applies when the state and local government's involved?
Isn't it true that Savannah State University case about foot washing did result in a victory of protection for the plaintiffs in that case? Because these issues are so relevant and important and central to our freedoms, don't you believe that the current law and the current litigation is favoring religious freedom, favoring religious protection in this balancing test, and that your bill will shift away from an appropriate balance?
No, I don't agree with that at all. I think that I don't think that a legal environment that requires 18 and 19-year-old students to retain legal counsel and fight with the university for years to have basic fundamental constitutional liberties respected is a legal environment that I want to see continue to persist. I think that we ought to have a legal environment that 31 other states have that, again, respects governmental interests, but does so in a way that also respects the right of free exercise of each and every Georgian.
I think our difference is that perhaps our difference may be that the constitutional protections are so important to all of us that whether that 18-year-old has to retain lawyer to protect his or her convictions is going to happen, because the courts are our protection, and they are our protection under current law. And your bill, I fear, constitutionally moves away from the balance that Georgia law protects citizens now.
Now, I would say to the point about the litigation occurring anyway, and I didn't bring this with me, but I'll be glad to publish it to the members of the committee. There's a Wayne State University law review article discussing the amount of litigation in RFRA states, and there's actually not as much litigation that has occurred, and I believe that is again due, as I testified earlier, to the bright line that the Religious Freedom Restoration Act provides policymakers.
Let me follow up with a couple of things that come to mind, and that is over the last numerous days we've received a lot of phone calls, to say the least. And I appreciate the concern people have, but the thing they keep emphasizing is pass Senate Bill 129 without any changes, period. And I think, as lawyers, we look at things trying to find what is the best balance And I think one of the things we, the lawyers in the legislature, both the Senate side and House side, have as a duty and responsibility is protecting the integrity of our code of laws. That's one reason I think I've served down here, and I think other lawyers will feel the same way, and I think you do the same way. We have a need to be sure that what we put into the law has clarity, so that who these people are that read the law know what were we doing, what were we trying to say, what were we expecting to be the application of that law, as well as the remedies under that law. And I preface what I'm asking now is I look at this in two things. Of course, you talk about discrimination. And I think the law addresses where there is discrimination. And I say that in the sense we have federal law as well as state law that says thou shalt not discriminate based upon age, sex, color of skin, origin, or belief. And so we do have that as a premise to what we're seeking to do here. And of course, part of it is belief. You can't discriminate, which means you can't just go out and harm people who may have a religious belief. But going to one area of the bill, I look at it and say, well, do we have the need to make any modifications? Maybe so, maybe not. But I look, for instance, the remedies you have in the bill. And it doesn't really speak as to what that remedy is. I say that since look at line 51 and 52. It says, assert that violation is a claim or defense in a judicial proceeding and obtain appropriate relief against government. And I don't know what you mean. And I say, I'm speaking as a lawyer, what is this potential relief I'm hoping to obtain, and what I expect the court to look at and read and say, this is the appropriate remedy?
Well, I would say, Mr. Chairman, that in most of these cases you're talking about injunctive relief. You're talking about, for example, in the examples that I gave earlier, allowing the student organization back on campus, providing the middle school student with access to school facilities.
Thank you. And you're aware in Georgia, as we sit here today, there is not the ability to bring an action in court to obtain injunctive or declaratory relief against the government.
Yeah,
is that true?
Yes, sir. I believe there's a bill on that.
There is a bill on that, but it hasn't passed yet.
Not yet.
So assuming that didn't pass, but this bill passed, do we have remedy?
I think it's very important for us to pass House Bill 59.
Well, there needs to be something about that point. Yeah. So I'm regardless of who's sponsoring that bill, there is, as we stood here today, a unanswered remedy, and really one the courts could not bring about by saying, if I came into court saying, Judge, my religious rights have been imposed upon by state law or county ordinance that restricting my rights as guaranteed under my state constitution, which I think is even stronger than the federal constitution on what is meant by religious freedom, because it speaks of freedom of conscience as a way that we worship in Georgia. Very strong statement. So we don't really have that answered yet. The other I point this out saying to everyone who's listening, there may be ways to improve the legislation, and that's one of the reasons we have a bicameral legislative body. So two sides look at it.
I certainly agree with that.
The other thing I'm wondering over here, I look at section 15A5, and I'm down to lines 75 and 76. And this talks about the exercise of religion meanings, and it says, as to the use of buildings or conversions of real property for the purpose of religious exercise. What are we talking about there?
Yes, Mr. Chairman. Following the adoption of the Religious Freedom Restoration Act, there was an act passed dealing with the land use by religious organizations, and that is where that language comes from, to deal with the use, building, or conversion of real property for the purpose of exercising one's religion.
And really you're talking about the restrictive right of use of property by a government with the enactment of either laws or ordinances. correct?
Yes, that is correct, Mr. Chairman.
And not saying that someone has the ability to obtain use of governmental property for religious
Oh,
purposes.
no, Mr. Chairman.
And that does that all, and that of course comes out of the federal law
It does,
as
Mr.
it
Chairman.
exists today. And in fact, that is applicable to the states. And I say that since as a city attorney, I've litigated in this area.
It is today.
Because
It is.
we had the Church of Scientology who had issues about whether we were allowing them the proper use of a piece of property in the city of Sandy Springs, and we weren't trying to stop the use of it, but they had to maintain a certain parking area, we'll say, for the number of people that had coming there, so it wouldn't be a imposition, we'll call it, on the surrounding area of trying to find parking place. So my point is, we do already address that issue under federal law. So my question is, do we need to address it with state law also?
The
And you got a lot of case law under federal law dealing with it.
the folks that I discussed that issue with felt strongly that we should include that in the definition, and so that is why it is there.
All right, and so we can have differing opinions about its inclusion or exclusion with regards
Certainly.
to what is appropriate legislation. Again, as I say, I'm trying to look at clarity and what we, the lawyers, do in trying to craft bills to come through a legislative body. Okay. I appreciate it. I'm not going to take the time away, but we've had you, thank you for taking the time to present the bill to us. I'm going to allow both sides to speak to it on an equal amount of time, and I'm not using your presentation time as a part of that proponent's opportunity to say so. So I know there's a number of you here. I'm going to have to just recognize people, and I'm saying if you will raise your hand if you wish to speak to the committee. And again ask for you, this is proponents of the Senate Bill 129. If you would raise your hand, I'll be glad to recognize you for the chance to speak to the committee. And I see, Mike, I'm going to let you come up first. I know you've spoken to us before, and again, I want to emphasize the need to be as brief as possible with your remarks. Thank you. Identify yourself to the committee.
Thank you, Mr. Chairman. Mike Griffin. I am the Public Affairs Representative for the Georgia Baptist Convention, also State Field Director for Georgia Right to Life, and we're here to speak in favor of Senate Bill 129.
We being who?
Georgia Right to Life and Georgia
both?
Baptist
Okay.
Convention. Yes, sir.
Okay.
This is a twofer.
Okay.
Saving a lot of time and money
That's
right
better.
here. Amen. Mr. Chairman, thank you. I appreciate your desire and your passion to get good bills. I've worked with you. This makes 8 years of this, and I know that we haven't always agreed, but you are kind of person that you're not disagreeable. At least you can be worked
We
with.
can respect
And
each other's
we
positions.
do, and I appreciate you, and I appreciate the hard work. This committee, I remember Representative Ed Lindsay kind of introduced me to this committee years ago, talking about it.
Right.
I won't use the term he used, but it was a very strong committee to make sure that bills were looked at very, very in much detail, and were very thorough, and we appreciate your commitment to that. You know, last week I've heard a number of times the text, and being a Baptist preacher, I'm familiar with the Bible a little bit, 30 years of preaching, but Isaiah 1:18 says, "Come, let us reason together," and I've heard that term being used, and let me tell you why I think we must do this. It makes sense to do it, especially in light of all the rhetoric that we've been hearing and the narratives that have been circulating around what RFA is and what it is not. So I think it is important that we reason together. Talk about the need for reason. It's unbelievable what people are saying. It's especially unbelievable in light of the fact that this legislation was passed with overwhelming bipartisan support with men like Congressman Chuck Schumer, Senator Ted Kennedy, President Bill Clinton, and last but not least, even President Barack Obama, who supported a state RFA when he was in the Illinois State Senate. Think about it. He supported the same kind of legislation.
Did he vote just president?
I think he did beyond that on this particular bill. And it's the same kind of legislation that you're looking at here before this subcommittee today. And a matter of fact, even Governor Nathan Deal who was at that time a congressman, was for this legislation. So he's already on record as supporting RFA before in 1993. It is absolutely unreasonable and unbelievable at the demagoguing and the fear-mongering and actually the religious phobia that really has been, in a sense, expressed about this bill. Accusations of things like discrimination against LGBT citizens, physical abuse of spouses and children, refusal to be served at lunch counters, the resurgence of Jim Crow laws, the rising of the KKK again, the threat of increased lawsuits and court cases, denial of HIV treatment, just to name a few. It's almost as if the sky is going to fall. And I really believe that in many ways our opponents are straining at gnats and swallowing the camels on this issue. All these accusations are not, and not one time in 22 years and over 30 states have any of them proven to be true. Not one shred of evidence to justify these claims. I think we need to sit down and do some reasoning, and I know that's what this committee is going to do. RFA is designed to be a no-brainer. It should not take time to decide. It's like asking a Baptist preacher if he wants any fried chicken. It's a no-brainer. Bring it on. And I think it's great. We have four and keep it coming. But 4 Democrats, 4 Republicans, that's a great way this bill ought to be passed, with bipartisan support in this subcommittee. Listen to what Ted Kennedy had to say. He said this act creates no new rights for any religious practice or for any potential litigant. Not every free exercise claim will prevail. It simply restores a long-established standard of review that had worked well for many years and that requires courts to weigh free exercise claims against the compelling state interest standard. Our bill is strongly supported by an extraordinary coalition of organizations which widely hold different views on many issues. He talks about the National Association of Evangelicals, the American Civil Liberties Union, the Coalition for America, People for the American Way, just to name a few, support the legislation. They don't often agree on much, but they agree on the need to pass the Religious Freedom Restoration Act because religious freedom in America is damaged each day the Smith decision stands.
I have to ask you to.
I'm fixing to finish up right here.
Yes, sir.
This legislation was passed unanimously in Congress, all but 3 votes in the Senate, and it was signed into law by President Bill Clinton. So, committee, not only do we need to get reasonable, we need to get honest. The RFA, as passed by the Georgia Senate, is not broke and therefore does not need to be fixed. That doesn't mean it might not need to be some tweaking, Mr. Chairman. I understand that. It just needs to be passed because it represents the federal RFA that has served our country well for 22 years. There's another quote from Isaiah I want to leave you with today, and I'm going to leave. I'm going to stay, but I'm going to leave this place right here.
Thank you.
Isaiah 5:20, it says this: "Woe unto them that call evil good and good evil, that put darkness for light and light for darkness, and that put bitter for sweet and sweet for bitter." I believe this committee will give this an honest look today and look at the facts, and I believe you'll be in favor of it. Thank you, Mr. Chairman.
Thank you, Mr. Griffin.
Appreciate it. Thank you.
Happy to see you. Mr. Hunt. I'm not showing preference, just calling people I know. So glad to have you. Identify yourself.
Thank you. My name is Garland Hunt. I am the pastor of the Father's House Church in Norcross, Georgia. I'm also with the Fellowship of International Churches as the executive vice president and a citizen of Georgia. Thank you, Chairman Willett, that I come before you. You've been a good friend for many years. Haven't come down here to testify very often, so this must be very, very deep in my heart as I come to you. I definitely support the Senate Bill 129. And I simply ask you and this committee to vote in favor, really, of the United States Constitution First Amendment. And as it's been talking to you about the Religious Freedom Restoration Act of 1993. As you already know, and it's been said, that the protection of my religious freedom is on a federal level, simply states that the government will not intrude upon our freedom unless there's a compelling state interest. So you can imagine I was devastated when I realized that the state where I was born and raised would not afford me the same protection, and that the federal government and 31 other states afford their citizens. I'm very concerned, actually even afraid as a pastor, that my freedom to live and speak my conscience can be overruled by a simple, untested collateral law that may deny me my inalienable right given by God. I voted for my elected officials to protect my religious freedoms. Many of my forefathers have died to protect our religious expression, freedom of speech, and freedom of religion. And quite frankly, as an African American pastor, I'm deeply burdened at the thought that my religious freedoms may be denied at such a low threshold. As you know, the impetus of the civil rights movement was fueled by the black church. Without this bill, the voice of the black church might be silent, and voices of African Americans' faith can be denied by the government without even a strict scrutiny standard here in Georgia. This brings me great concern, and my precious right could be denied so simply. I'm highly also offended, I must say honestly, when efforts to protect my religious conscience is made analogous to racially charged discrimination accusations. This is blatantly untrue, and characterization of this bill is not true, and I resent that even as an inference that that kind of ill intent is here. I love this state as you all do. Please do not turn your backs on the faith community of this state. Please do not give in to political pressure. Pass this bill without amendment. The scriptures are very clear. The Lord is our judge. The Lord is our lawmaker, and he's our king.
Thank you. Let's see. I'm going to start over here on your left, and I believe this gentleman right here would like to come forward and speak.
Thank you, Chairman Willard, and also I do have some handouts.
Well, good. Thank you. If you just hand those over, slide them across, we'll have those handed out. And
right.
Give us your name and who you represent.
All right. Well, my name is Philip Bell, and I'm the State Legislative Director for the First Amendment Partnership. We're a national organization that works with national faith communities on legislation like the Religious Freedom Restoration Act. And since Senator McCoon was so comprehensive in what he talked about, I just wanted to tell a quick story. I grew up in Florida, and there's a guy there, 90-year-old, named Arnold Abbott. Now, Arnold Abbott, he and I are a little bit different. First of all, he's 90 and I'm 34. He's a liberal Democrat. I'm a conservative Republican. We're both Christians. He wants to feed the homeless. And he's been feeding the homeless for quite some time, actually in contravention of a statute in the city of Fort Lauderdale that says he can't feed them where he's feeding them. The reason why is it's impacting commerce, it's impacting the cleanliness of the beach and the like, and the mayor also believes that it's worthwhile to have them move on someplace else so actually they can improve themselves. But back in 2001, there was a RFRA case using Florida's law, which is substantially similar to what's being considered here in Georgia, that ruled that Mr. Abbott was in fact free to feed the homeless, but at the same time, the city had a compelling governmental interest in making sure that their needs, commerce, cleanliness, and the like, were seen and maintained. And so the result of that, while he does continue to feed the homeless and go to jail and the like, the result of that was protecting the government's interest in making sure the city is clean and also protecting his freedom of religious exercise. That, in a nutshell, is what the Religious Freedom Restoration Act will do. It's not for discrimination. It is for the preservation of the freedoms of everybody here in this room. And passing that legislation is a common sense act for this committee, for this House, and for those in the state of Georgia. And other than that, if you have any questions, I'd like to thank you for the opportunity to speak.
Well, thank you. Any questions of the presenter? We appreciate your being here today and being with us. We'll come across.
Thank you, Chairman.
I've had anyone else on the first row? Yes, ma'am. Please come forward.
Good afternoon, Mr. Chairman. I'm Tanya Diddy, State Director for Concerned Women for America. I do have handouts, and Jane Robbins with the American Principles Project had to attend another hearing, and I have her testimony as well. So
Thank you.
if I can,
That'd be
I'm not
very
sure who
helpful.
to give those to, but
Do
I'll
that. Just slide across.
Thank you. Thank you very much. I will be brief. I won't cover anything in my testimony that was already mentioned. So I'm here in support of Senate Bill 129. We would like not to have any amendments, though your reputation does precede you as far as one that wants to be thorough, and I respect that, Mr. Chairman. So the only thing that I would like to add this afternoon on our support for this bill, besides what has already been said by Senator McCoon and those that have preceded me, is as this fight began actually last legislative session, I took the time to look at some of the concerns from those that oppose this bill. And one of the concerns had to do with the reputation of Georgia and Georgia's economy, and that businesses would choose not to come to Georgia, that we would not be an attractive state in which to do business. So I took a little bit of time to research this particular thing. I tell you, we've got a governor who brings jobs to this state. And we have had a lot of companies come into our state since he's been governor. We've had companies that have expanded in this state. To example, Travel Sky Technology, Caterpillar, Baxter International, Mercedes-Benz. The list could go on and on. I chose just a few. And as I researched their press releases and researched articles in the newspaper, I couldn't find any of them that said the reason they would choose not to come to Georgia was because of us. We didn't. The reason that the reason that they really selected Georgia was because we didn't have a state RFRA. And so I don't think that really holds water. And as I look around the other states that surround us that have RFRAs, they have economically stable states, and they brought in a lot of commerce as well. So I don't believe that is a solid argument on that. So just really to conclude, I would like to leave you with Justice Anthony Kennedy. He had a concurring opinion in the Burwell versus Hobby Lobby and the Conestoga Wood versus Burwell case concerning the fundamental freedom of free exercise of religion, and I've heard that discussed today among the members. And this is what he says, quote, "In our constitutional tradition, freedom means that all persons have the right to believe or strive to believe in a divine creator and a divine law. For those who choose this course, free exercise is essential in preserving their own dignity and in striving their self-definition shaped by religious precepts. Free exercise in this sense implicates more than just freedom of belief. It means, too, the right to express those beliefs and to establish one's religious or non-religious self-definition in the political, civic, and economic life of our larger community. I believe that religious freedom is the bedrock of all our liberties, and it must be protected. On behalf of the members of my organization, I urge you to side on the side of religious belief, those that support this bill, those that want to be protected and have their religious freedoms protected. And we ask that you support Senate Bill 129 with no amendments. Thank you.
Thank you, Ms. Diddy. We're coming back across the first row. Anyone here wishes to speak on the first row?
Just opponents, proponents.
Proponents. Coming across the first row. Second row, okay, this gentleman back here, come forward. If you give us your name and who you represent.
Chairman and honored members of the committee, my name is Dr. Pallas. I represent myself as a citizen of the state of Georgia for 31 years now. I have a PhD in systems engineering, and I'm a registered PE in the state of Georgia. And I come here to speak out against discrimination.
Well, let me stop.
Yes, sir. Don't stop me, please. Don't stop me, please.
No, sir, don't tell me.
I'm speaking for 129.
I have to get off. If you'll listen to me, I said proponents at this
yes,
point in
sir.
time.
I'm speaking in favor of 129.
Okay, well, you said opposed to it.
No, I'm opposed to discrimination.
Okay, go ahead.
Thank you, Mr. Chairman. As an immigrant, my family left Eastern Europe before the Iron Curtain fell, and we experienced a lot of, and my extended family we didn't all leave, experienced a lot of discrimination based on our religious beliefs. My mother, who had a college degree and When I came along, she decided to stay at home. I asked my mom, why is it we can't say a short grace before meals? She said, well, these two children, we don't know what their families are like. And we couldn't, in our own home, say a grace before meals because of the system that was in place. As an immigrant to the Deep South, I experienced discrimination due to language, due to cultural differences, and severe financial discrimination. In my undergraduate days, I actually went to a Freedom Quilting Bee, a weekend-long Freedom Quilting Bee in South Alabama, well, South Central, near Salem. I'm not sure the exact small place, I can't say it was in Salem, but near it. So I'm saying this, I've experienced discrimination. And discrimination can cut both ways. And sadly, I think we live in a day and age when people of faith are being discriminated against. So I would ask that the committee give this due consideration, that this is a good and fair law which has been in place for over 2 decades now at the federal level and in the majority of the states, that it will not negatively impact, but it will reflect very positively on this great state of Georgia. Thank you for your consideration.
Thank you, Doctor. And next on the second row, do we have anyone come in the second row, excuse me, coming across the second row? We have this gentleman and Mr. Galloway. Come on, y'all come around together and we'll hear you. I know if you're able to do that. I know you're speaking separate. Just bring you around about the same time where we have. Can you get through? You have a way to get through? All right, you stand by, Miss Galloway. Just stand by. Come on. No, you, sir. Sit down. You're fine. I didn't mean to stop you.
I have some copies.
Yes, sir. Tell us who you are, first of all, and who you represent.
My name is Adam Woodward, and I'm a law student at Emory Law School. I'm a member of the Center for the Study of Law and Religion. While I don't represent them officially, I've had the benefit of benefiting from their education, and I've spent a lot of time studying RFRA.
All right, thank you. Good. Well,
there's two.
You got your pass out?
So
Yep. Fine. Please have a seat. And what was your last name again?
Woodward.
Woodward, yeah.
Woodward.
Proceed.
I've had the benefit of studying under many incredibly brilliant, gifted scholars at the Center for the Study of Law and Religion that focus specifically on the issues of religious freedom. In fact, many former colleagues of Representative Oliver's, including the preeminent John Whitty. There's two. That was a stack of two at a time.
I got you.
Sorry. I collated them.
Thank you.
Consequently, I've come to see the importance of protecting religious liberty as a matter of law and the gaps and the huge holes in our current protection of religious liberty in the state of Georgia as a result of Employment Division v. Smith and City of Bernie, as Senator McCoon so eloquently put it already. The two materials before you, one is a letter by Professor Douglas Laycock from the University of Virginia, one of 14 law professors, the most cited by the U.S. Supreme Court on the issue of religious liberty. And the second document is the list of examples of religious discrimination in the state of Georgia, which Senator McCoon was mentioning earlier. What is important and notable, I think hasn't been mentioned so far, is that when it comes to fundamental constitutional rights, strict scrutiny is the normal standard. Strict scrutiny is the typical standard of review, whether we're talking about freedom of speech, freedom of the press, freedom of association, and the current regime that we have sets up ironically, the first freedom mentioned in the Bill of Rights as a second-class citizen, a second-tier freedom when it comes to state law. The litigation battles trying to find some penumbra of some provision, whether it's RLUIPA or the state constitution, somewhere to provide relief to these religious claimants, is quite a hassle because of Employment Division v. Smith and City of Bernie v. Flores, which basically said, yeah, free exercise, freedom of speech. Well, if we want to burden your freedom of speech, we're going to apply strict scrutiny to that law. It has to be a compelling interest, narrowly tailored. If we want to, in fact, the original Roe v. Wade decision said, if we're going to put burdens on your right to abortion, well, that's a fundamental right. It needs to. We need to have compelling interest, and it needs to be narrowly tailored. This strict scrutiny standard is always what the Supreme Court applies, and to not apply that to state laws that might abridge the free exercise of religion is, in my mind, a travesty. Furthermore, as some have said, the argument is that the Georgia Constitution protects us. But unfortunately, because of the way it has been interpreted, or honestly not interpreted, it does not. After doing a Westlaw search, the only decision I could find interpreting the Georgia Constitution, it's Article 1, Section 1, paragraphs 3 and 4, that provide religious freedom protection. There's two cases. Jones v. City of Moultrie, and I believe Ferguson v. City of Moultrie, both of which applied a rational basis standard a la Employment Division v. Smith to religious claimants in the state of Georgia 50 years before the Smith decision was decided. So we've been living without these protections for quite a while now. Finally, few closing thoughts. Examples. I know one of the constant refrains that we hear as proponents of this bill is, well, where are the examples of religious discrimination? Why do we really need this bill? Isn't this just a solution in search of a problem? In that letter from Professor Laycock, you'll find several examples, but one of the most notable ones, it's not happened in the state of Georgia, but there's no reason to think it couldn't. It involves the possibility of dying for your faith because of government intransigence. And this came to pass a real case in Kansas. Mary Steinmetz needed a liver transplant, and because she was a Jehovah's Witness, the surgery had to be done without a blood transfusion. A bloodless liver transplant was available in Omaha, and it was cheaper than a liver transplant with blood transfusions that was available in Kansas. But Kansas Medicaid had a rule, a neutral law of general applicability per Employment Division v. Smith, no out-of-state medical treatment except for medical necessity. And the state said that religious obligations did not create a medical necessity. While the court was debating about whether or not to enact the rule from Employment Division v. Smith or the strict scrutiny standard of RFRA, Miss Steinmetz's health deteriorated to the point that she was no longer able to receive the liver transplant. She died in 2012 despite winning the court case. If Kansas had had a RFRA, then no legal battle would have been necessary. It would have been clear that Kansas had to work with her to provide a reasonable accommodation for her religious beliefs. This echoes the sentiments, I think, that Senator McCoon has stated earlier, and I think a rebuttal to many of the claims. Well, don't many of these religious claimants ultimately prevail, whether it's the foot washing students at Savannah State or at other universities? The answer is yes, sometimes, but not always. But that difference between a bright line standard that has to be litigated and one that does not can spell the difference between life and death for some religious claimants. Thank you very much for your time. I'll take any questions.
I'll just comment. I'm looking at some of your examples here, and I can see where a lot of times this has apparently been an issue that arises as a result of the school situation because of the need that we compel students to attend schools, and therefore there has to be that separation of religion and schools. Is that what we see a number of these happening as far as the events? And I'm saying this like clubs,
right?
Religious clubs in schools.
Sure.
And the fact that no, the school says we're not going to have religious clubs in schools.
With the absence of RFRA, many school districts are left in a hazy place, and they're left unaware of recent developments in Establishment Clause law as well as in free exercise law. There are several Supreme Court decisions, including Rosenberg and Zellman v. Simons Harris, that establish that equal access does not violate the Establishment Clause.
Are you looking to have RFRA overcome what are the requirements that you have with state separation of religion?
No, sir.
Well, that's what these examples are apparently addressing. Is where you've had the brief statements about them, but I say, okay, you can see that's where the school is saying, no, we can't do that as a school program. It can't be done in school because it allows now that very bright line division we have between religion and state education.
I understand that, Chairman, but the Supreme Court has held that allowing equal access, whether it's to after-school facilities or the right to form religious clubs or the right to post on bulletin boards like other ideological or interested groups, for religious people does not violate the Establishment Clause. Equal access does not violate Establishment Clause.
Thank you, sir.
Thank you.
Ms. Galloway, would you have a question, Ms. Oliver, excuse me.
Mr. Chairman, I have a logistical question. There are people who wish to speak who are in the hall who had signed up with Ms. Womack, and I didn't know how you wanted to handle
Well,
that.
we don't. I've given an hour each side, and then we've gone now 30 plus minutes on, because I did not count the time for presentation by Mr. McComb. So I want to just be weighing this evenly as I can for
Yes, sir.
hearing purposes. Thank you, sir.
Thank you.
Ms. Galloway. If we get through with who's in the room, and someone wishes to come in and speak, and we have time, then I'll be happy to do so.
Thank you,
Have
sir.
a seat, Ms. Galloway.
Before I sit down, I would like to ask, there is a gentleman who used to serve in this body who came down here today for the purpose of testifying, was not able to get in the room, and he is out in the hallway. If I gave my time up to him, even though I'd very much like to
Who's
testify, Representative Bob Snelling.
Okay, ask him to come in.
Okay, thank you, sir. I appreciate it. Bob Snelling, please. Bob Snelling, out loud.
Bob Snelling from Douglas County. Come in, Mr. Snelling. You've been subpoenaed to speak in lieu of Ms. Galloway.
Well, thank you, Mr. Speaker. This is actually quite a surprise, but I thank you for the opportunity. Thank you very much.
Good to see you again.
Good to see
Saw you
you
earlier
too.
today.
Thank you very
We've
much.
asked people to be as brief as they can with their comments because we've got so many people trying to speak.
All right, I will try to run through this quickly.
All right.
It's in 18-point font, if that helps.
Okay.
Chairman Willard, distinguished members of the House Judiciary Committee, I thank you for your service to the state of Georgia. For the opportunity to speak today, my name is Bob Snelling, a former state rep who has served where you are serving and who therefore understands the pressure of dealing with high-profile and contentious issues. Some of you remember the day when State Representative Tyrone Brooks had 20 years of legislative effort rewarded in the year 2001 when Georgia made its first change to the state flag in almost 50 years. I was here. As a Republican legislator, I voted to change the flag and as a result bore the hyperbolic, undignified, and just plain nasty responses for that vote, even though my vote was clearly the right thing to do in spite of my own party's and other lobbying pressure. Some of you were here on that interesting 2001 morning. I know Representative Willard, you were, Chairman Willard. I have been where you sit. I have done the right thing when necessary and know the pressures of sitting where you sit when very hard choices must be made. I will skip the personal story in deference to the committee. To get serious, I am here to ask you, leaders in the House, as strongly as I know how, to allow the full House of Representatives to vote on the floor on the unamended version of Senate Bill 129 before Sine Die 2015. The legislation is necessary and way overdue. In my view, to deny this opportunity would be an irresponsible act of legislative injustice. Why do I feel that way? There are many examples across the state where free speech rights of Christians or religious organizations have either been infringed upon or denied outright. I will try to make this real fast. Free speech issue in Georgia Tech a few years ago, it took the courts to allow students to have the right to speech outside of the unconstitutionally imposed free speech zones. At the University of Georgia, a religious organization, and I just don't get this, but a religious organization was denied the right to set religious qualifications for leadership in a religious organization. I scratch my head over that and say how and why. The club was uniquely denied the privileges given to every other student organization. At Georgia Southern, a student was handcuffed, hauled away, and held for 6 hours because he was within a free speech zone speaking freely. This is insanity. How can these things happen in a country, a state, where we hold free speech rights and religious freedom so dearly? If you know, I'm just going to assume that you know the story about Eric Walsh, an African-American PhD, totally qualified to work for the state of Georgia as the Northwest Georgia District Public Health Director in Georgia. He was hired, actually negotiated a higher salary, and because of his qualifications was hired But then somebody said, oh, by the way, Mr. Walsh, give us some copies of the sermons that you preached in California. We need to know what they were about, and I don't have any idea what the content of those sermons was. But I know that once the folks received those those sermons and reviewed them, all of a sudden he was unhired and he did not get to do that job, and that was in a potentially career-damaging move for that man who was an African American, PhD, totally qualified to do the job. I think you know that as of today it's not 31 anymore, but 32 states who have adopted a form of RFRA. You've heard the hysterical allegations of the potential resultant child abuse or prejudicial treatment of classes of people as a result of this proposed new law. I challenge anyone to provide evidence that backs up this hysteria. None of these things has happened in 31 states, and our side has continued to ask for evidence where this has happened, and nobody can provide that. And I would ask you to dig for, examine the evidence. I love this country. I don't want to stand by silently anymore as our system crumbles, because there are few courageous leaders who will stand against the devastating effect of political correctness at the expense of religious freedom. Those who use political correctness to seek tolerance for themselves and deny that very same tolerance for the strong beliefs and convictions of those with whom they disagree. This is simply not right. Chairman Willard, ladies and gentlemen of the committee, like changing the flag in 2001, the right thing to do in 2015 is to allow a floor vote by all representatives on Senate Bill 129 unamended. To block that opportunity would be an irresponsible act, in my view, of legislative injustice that displays not the benefits of, but rather the uses of power that are inappropriate that can happen when what we so want to believe is representative government.
Thank you, Mr. Dowling.
Chairman, thank you very much.
And that vote was done the sixth day I was in the legislature.
The sixth day? Was it that early, Mr.
Yes,
Chairman?
sir.
Wow.
Sure was.
Wow.
And Mr. Weldon.
Thank you, Mr. Chairman. Thank you for being here. You mentioned the public speech at Georgia Southern University, and you stated that they had or have free speech areas at Georgia Southern. I don't think I understand that, because they're at a state-owned university, and the state are the citizens of Georgia, correct?
Yes.
They own that school, and there are free speech zones.
At Georgia Tech 10 years ago, there were government-instituted free speech zones that are no longer there at Georgia Tech. There was a major court fight where those free speech zones were basically abolished, but it took a court fight for those to be done away with. I don't know the final outcome of what happened at Georgia Southern University. My understanding is that a student was even exercising his own free speech rights there and was hauled away because he wasn't given a permit to do that before he did so. Okay. That's my understanding.
Thank you.
Thank you. And appreciate you being with us today, Mr. Dowling. Good to see you again.
I really appreciate you letting me come in the room.
Absolutely.
Thank you. Thank you, Mr. Chairman.
We're back on the back row. Proponent to come forward.
Andrew Patterson, private citizen, and recently called to preach. Once I do appreciate the bill, and my biggest concern is, as a minister, what would be the protections? The concern is the loss of protection as a minister to preach what I feel is God-given, and I feel like I need to preach, and I feel like this bill will protect that. And I was just curious if I could find out what the protections are for.
Well, that's what we hope to have clear when we pass the bill, is what will be the protection that you'll have. And of course, the idea is to have have meaning enough in the law that people can read it and understand it. That's what we're trying to do.
Yes, sir. And once again, I do appreciate
Sure.
the opportunity, and I pray that y'all will, follow divine inspiration
Thank you.
and make the right decision. And I do appreciate your service.
Thank you.
It's very important.
Keep
Thank you.
praying for us. Thank you so much. Next, is there anyone else who wishes to speak? Proponent, please come forward. And give us your name and who you represent.
Yes, Mr. Chairman, I'm Nate Bednar, pastor of Metropolitan Baptist Church and also one of the Sandy Springs Police Chaplains. It's good to see you once again.
Nice to see you.
Yes, sir. I appreciate the work that each of you has done so far, and we certainly have a huge challenge in front of us. But I wanted to remind the committee today of three major points that were written back in 2013 in the Capitol Commentary. And in fact, what it says, in effect, RFRA reinforces three foundational commitments of American constitutionalism: limited government, pluralism, and religious freedom. First, RFRA is a rare reminder that American government is a government of limited power, one that defers to its citizens' religious liberty except in compelling circumstances. Number two, by even-handedly protecting religious freedom of all citizens, RFRA embodies American pluralism. Finally, through its passage of RFRA, Congress has redirected the U.S. to religious liberty for all Americans and to the foundational principle that American citizens have the God-given right to live peaceably and undisturbed according to their religious beliefs. In RFRA, a nation begun by immigrants seeking religious liberty renewed its pledge to be a perpetual sanctuary for all faiths. I am asking you to pass and to allow to pass for a vote Senate Bill 129 in its unamended form, which will put the burden on the state government to use the least restrictive means possible from violating someone's religious freedom. Thank you, Mr. Chairman.
Thank you too, Pastor. Nice to see you again. We're going to take one more back here if we can, if that's the gentleman like to speak, and then we're going to take a 5-minute break, and then yes, sir.
Thank you, Chairman, ladies and gentlemen. I appreciate the opportunity to be able to speak. I would first say I feel like a fish out of water here today. I am a Baptist pastor. My name is Chris Webb. I pastor Grace Baptist Church in Eatonton, Georgia. That's down around the Lake Oconee area. I first just want to say that I thank you for even taking the time to consider such an important matter. But I am here today. In fact, I am representing, or we just kind of at the last minute last week, after several attempts to try to speak with, making phone calls to the Speaker's office. Personally, I was hung up on being as very kind as I can today. I want to share some things with you that I think are important regarding this bill. I did personally come up. This is my 6th trip up from Eatonton to the Capitol just to speak with some of you in regards to this bill. Tried to speak to the Speaker on Thursday as well. Was unable to. However, I think word is.
Let's get your point for us, would you? You have something to say about the bill?
Yes, sir. I sure do.
Okay.
All right.
Please do.
Well, let me remind us first that we're not a democracy here today. We are a constitutional republic, which means that we're governed by the rule of law. Yes. And America's founding fathers were very careful to ensure that not just the right to believe as we see fit, but they were very careful to ensure that we were able to practice what we believe as we see fit. That being the case today, I have with me just a last-minute grassroots effort of getting clergy and pastors and Christians, faith-minded individuals that agree with us. You'll see these stickers. One of my church members printed these, and today I'm here representing them and myself. And we are extremely disappointed that a bill that merely reiterates Georgians' First Amendment rights, which is the freedom to practice one's sincerely held religious beliefs without threat of undue punishment by the state or other citizens, is needlessly being stalled since deeply misleading criticism surfaced. Georgia Senate Bill 129 is modeled directly on and quotes the bipartisan Federal Religious Freedom Restoration Act that was signed into law by President Clinton in 1993. My question today is, was Bill Clinton discriminatory? Was Ted Kennedy discriminatory? What was Dianne Feinstein discriminatory? John Kerry? Nancy Pelosi? Harry Reid? Were any of the 97 senators and 425 representatives who all voted to pass the federal RFRA to protect basic First Amendment rights of religious freedom of individuals, were they discriminatory in any way? And the answer to that is no. They passed that bill to reiterate the American idea that people of all belief systems, people of all races, people of all backgrounds and all sexual attractions have the freedom to practice their sincerely held religious beliefs, unless the government can prove a compelling state interest in curtailing that practice. Under the City of Bourne versus Flores, 1997, the U.S. Supreme Court instructed states to pass their own RFRA bills. We're almost 18 years behind the ball now. Contrary to now popular falsehoods, no RFRA has ever been used to discriminate. In fact, since RFRA was passed in 1993 and adopted by many states, not a single person has used RFRA to defend racist business practices or discrimination against any people in court. I would even say this. The left, as documented by the federal RFRA vote in 1993, used to understand this. For in 1993, the left cared about individuals' rights. That's what made them liberals. They didn't think that the government should be able to tell individuals not to do things simply because they didn't personally agree with their choices. And sadly, now those voices are drowned out by a mob mentality that seeks to impose their views and actions on everyone else, which is the epitome of intolerance. So much for tolerating different views and lifestyles, so much for live and let live. I'm here today to simply ask that we move forward giving our House a floor vote regarding Senate Bill 129 without any amendments, because the amendments, as we are already discovering, may cause us to come back to the table to create more legislation to clarify the amendments. I want to make one closing remark and maybe just give you a question that in your mind you might answer, because I've asked it to many here under this dome and have yet to get an answer. And that question is simply, as a preacher of the gospel, I perform weddings. I perform weddings regularly. I typically require those that I perform weddings for, I require them to have premarital counseling. I believe that's beneficial to them. It's beneficial to us as government as well. It's beneficial to keep that home together. However, there are times when I may counsel a couple that I, because of situations or things in their life, that I may say I can't perform that. I can't perform that ceremony. What law do we have in the state of Georgia right now that protects me so that I might keep doing that?
I don't think you need a law. That's your choice. That's your God-given right to make that decision. You might tell the people you counsel with, too, Pastor, by having that counseling, they can save the cost of their marriage license.
Oh,
we
understand that.
Something else we've done.
All right, but here's where we've got to look at.
Right.
Given that the Supreme Court right now is supposed to take up a very critical ruling about our marriage laws in Georgia.
Yes, sir.
What do we have in the future that would help protect me if I choose not to perform a particular wedding?
This law wouldn't do it. Ask your sponsor here. I'm glad to have you here today. Thank you very much. We're going to take a 5-minute break at this point in time. I think some of us need a few minutes to stretch our legs. I want to first recognize someone very special here to me, and that is my lovely wife, Vicki, who's been demonized. So people thinking she believes one way or the other when she hasn't even expressed to me what her belief is, but I'll also say to her, thank you for spending your 31st wedding anniversary here with me today. 5-minute break is fair and balanced as we can. We're going to next have a series of individuals who wish to speak. And as the opponents to the bill, I will start with Mr. Bowers back here. Mr. Bowers, if you'd like to come forward. And give us your name and who you represent, please, sir.
Thank you, Mr. Chair. My name is Mike Bowers. I am with the law firm of Balch and Bingham. I am here as the attorney for Georgia Equality. I speak in opposition to the bill. I speak in opposition to the bill respectfully of all the opponents, but in opposition. 3 reasons I speak in opposition. Number 1, I respectfully believe that this bill is an excuse to discriminate for the reasons that I will state. Number 2, I believe that this bill gives every individual the opportunity, based on his or her view of their religion, to unilaterally interpret the law to the detriment of the state because of the manner in which person is defined and the manner in which religious practice is defined. And finally, I believe that the bill is going to create enormous difficulty in enforcing and administering the law for the very same reasons. Now, why do I say that this is an excuse to discriminate, practice invidious discrimination? It's the reason that the representative over here on my left raised earlier, and that's the definition of what is the exercise of religion. And included in that definition is this: the right to act or refuse to act in a manner that is substantially motivated by a sincerely held religious belief, whether or not the religious exercise is compulsory or central to a larger system of religious belief. And the way that's been interpreted,
could I ask what line he's referring to, Mr. Chairman?
I do not have the same.
I think what we may give to you is a copy of the current bill, Mr. Bauer. I think that some things that were coming through the Senate may have been modified or removed over a period of time. It is in what was labeled Code Section 15 or 5015-3. Yeah.
I asked that, Mr. Chairman, because the definition he gave is not in the bill that we have.
Yes.
Okay. Well, look at. It would be exercise religion means any exercise religion, whether or not compelled by or central to a system of religious belief, which is line 71 and 72. It's the same thing.
Right.
Essentially the same thing, Mr. Fleming. And what that's going to do, although the language is slightly different, that will give any individual the right to say, look, this is my religious belief, and as a result, I can do pretty much whatever I want to, and in terms of doing or not doing. So that if I want to not bake a cake, I don't want to engage in this or that activity, I can do so. that is an excuse to discriminate. I don't think there's any question about that. And that is an excuse to exclude. I do not think that is good law. That is not something that we should be enacting in our state. And I think it will be much to our detriment. And the question that Mr. Bruce raised earlier, I think it was to Senator McCoon, what can people do or not do given the passage of this kind of legislation? They can do a lot that is detrimental to their fellow citizens. And I think what this will do is it will exclude. It will give the opportunity to exclude in the name of religion. And I think that's a disaster. I think that is an unmitigated disaster for this state. And I do not think that is what we ought to be doing in the name of religion. And I say that most respectfully. That's number one. Number two, everybody is going to become the arbiter of what the law is. Person is going to become, both corporate and individual, natural citizens are going to become arbiters of what the law is for all kinds of things. Vaccinations, what courses in school are going to be administered, teaching courses. That's not good. And I respectfully disagree with Senator McCoon as to these kinds of decisions having a bright line test. I think exactly the opposite will happen. You're going to create far more potential litigation and legal situations because you got more legal questions arising. That's what's going to happen. And I've been around this business a long time, 41 years, and there are very few things that you can do with laws, passing them here in the General Assembly, that are going to be, that are going to preclude legal questions. And for cops on the street, for hospital administrators, for teachers, I think this bill will be a disaster. And therefore, I would strongly urge you not to pass this bill.
Thank you, Mr. Bowers. We have over here, I believe, who was yours or waved off? Okay, I recognize you. Sorry.
Thank you. I recognize you too. Mr. Bowers, I understand your concern and would be a little bit more sympathetic to your concern if this were the first time that this legislation had been adopted anywhere in this country. Is there any state that has adopted this in the years or even decades that it's been in effect, that the concerns that you've expressed have been played out either in the courts or in civil discourse or whatever?
I do not have any reported cases. No, sir, I do not. I have examples of where these kinds of concerns have been raised. For example, just some examples. Police officers in Oklahoma raising, we will not go to an Islamic banquet and serve as security because it's against our religion. That's the kind of thing that was raised. Citizens using RFRA to defend against violations of a city noise ordinance in Pennsylvania, in Idaho. A citizen saying, I'm not going to give you my Social Security number under RFRA. Those are the kinds of things you're going to have. Have they all been successful? No. But that's the kind of thing you're going to have. Indian tribe killing eagles, protected species, under RFRA, saying that's protected, we're protected because of religion. There are all kinds of things that will occur. And here's the problem, sir. How will this be interpreted under Georgia law, given our Georgia Constitution, which is peculiar as to the religious freedom provisions? I don't know of any exactly like we've got. I don't know. I can't answer that for you because, as Senator McCoon said, we haven't really had an interpretation of our religious freedom provisions of the Georgia Constitution since about 1943. I don't know. I don't know how it's going to be interpreted. But I go back to what I think it was an Englishman, Lord Acton, A-C-T-O-N, once said, "Power granted is seldom neglected." I know what the bill says in the definition of religious freedom, and it is extraordinarily broad. Extraordinarily broad. And that language can mean anything. How a court might interpret that language: any exercise of religion, whether or not compelled by or central to a system of religious belief. That's extraordinarily broad.
Thank you.
And that's going to be in the eyes of he or she claiming the exercise.
Mr. Fleming.
Thank you, Mr. Chairman. Mr. Bowers, thank you for coming today. The first question I had for you was the one that Chairman Powell asked, and so I have a second question that plays off of that. I know you've been trying cases at least since 1986 because that's when I was an intern for this committee in college, and you allowed us to come over to your office across the street and talk to you. So more than 30 or 40 years you've been trying cases. You're not trying a case today, but you came in here today to make an argument, and you have absolutely no cases whatsoever to support your argument out of 31 states and the federal government. How many times have you gone into court with no cases whatsoever to support your argument and been successful at that?
Many, because I've got the language right here. Many, many, many times.
90% of the time you're successful, 50% of the time you're successful?
I don't always have cases. I got the statutory language right here. It's plain black and white. I don't need any cases. I can read and write. I can read and write pretty well.
Well, you've been successful, so I'm going to adopt your theory, and I'm going to go into court with no cases to support my position in the future.
It's not to be argumented with the witness. Anything further, Ms. Fleming?
That's good. Thank you.
All right. Thank you. Anything further of Mr. Bowers? If not, we appreciate your coming today. And
thank you for having me. Can I keep this?
Yes, sir.
Thank you.
Mr. Lindsay, you've come and waited, and I'll recognize you next. Recognize you as a person, then.
May I be excused?
Yes, sir. You may be. And I want to mention, being excused, if you need to go to your committee, you're welcome to do so. And I understand if you have to leave, that's the case. So you got a bunch of people.
They've moved us a little bit later because of the
Okay. Well, we're. Yeah. Okay. Thank you. All right. Guess. Got some case
I appreciate the opportunity to come in here, Mr. Chairman, and I appreciate you
Always
inviting me
a joy
to come down.
Have you come back?
For the record, my name is Edward Lindsay. I used to have the honor of sitting in this room for many hours with you, and I appreciate you inviting me to come down here. I come today to neither sanctify nor vilify the bill, but to simply ask that you do what I have witnessed in this room for many years, and that is taking bills of good intent and refining them and taking them out of this committee better than they came in. To those who are here who aren't familiar with the process, let me tell you that in 10 years in the General Assembly, I passed carried somewhere around 3 dozen bills, and I don't remember a single one that I passed that came out with no amendments out of the committee process. And quite frankly, I generally believe that they came out of the committee process a lot better than they were when they went in. I have given y'all some thoughts that I have in terms of ways in which I think the bill can be improved and be able to operate better here in the state of Georgia should you decide to pass it, and also to protect against some of the unintended consequences that some folks have registered concerns. It has been said many times that the federal government has passed this bill, and that's right. similar bill, and 19 other states have. We now have the advantage, have passed statutes, and then there's another 12 or so, I believe, that's been done by court decisions. We have the advantage of looking at what those other states have done and seeing what they have amended to the original bills, and quite frankly, to make it better. My hope here today is to very briefly, Mr. Chairman, walk through and give you some suggestions that I think will make Georgia's RFRA a new model for other states to consider. And I have before you my thoughts on this. Regarding the legislative intent, I have no problem at all with that remaining in. It's the concern, of course, is that it's not binding upon any court. While it may be persuasive to a court to consider, it has no binding authority. So that's one of my concerns.
Do we do that usually with statutes?
We do it very rarely, Mr. Chairman. I can remember we do it occasionally. We don't do it very often, but we do it occasionally. Under definitions, I've added in my proposal that I'm giving to y'all a couple of additional definitions, and I'll explain why that I have in a minute, for fraudulent claim and frivolous claim. And I've also added the definition of substantially burdened, which has been a standard that's been used in many other states as well. So I thought it would be a good idea to go ahead and put it into the statute should y'all decide to do so. Moving, and that's in 15A-2. 15A-3 is the heart of Senator McCoon's bill, and I believe that it should remain untouched. Quite frankly, as Senator McCoon has stated and other folks have stated, this has been a language that has survived for the last 20 years and has been received fairly favorably by other states. The parade of horribles that some people will give to you, I simply have not seen a great amount of that. Although I do think there are certain things that we do need to be careful of, and I'll talk about those in a minute. But I especially was mindful of what Senator McCoon said regarding establishing bright lines. And I want you to remember that phrase because I'm going to come back to it in a minute when it comes to certain exceptions that I'd like for you to put into this bill in a moment. One of the problems with the bill as written at the present time, and you touched on it, Mr. Chairman, is it doesn't really clarify what those remedies are. And I'd like to sort of look for you to look at 15A-4 and 15A-5 together, because I do think that we need to set up a process by which an individual who feels aggrieved should have an ability to come to that government and seek redress. The last thing I want to do is have a race to the courthouse for a lot of governments, particularly local and county governments. And to the extent that you could first have an ability for that individual to go to the county government and say, hey, look, I think what you did is wrong. I'm going to give you a time period to fix it before I file a lawsuit. I think that will assist a lot of our governments throughout our state to give them a chance to fix the problem before it actually goes to a lawsuit. As someone who's been a litigator for 31 years, I always tell folks the best lawsuit is the one that you don't have, the best fight is the one that you don't have to fight. I always tell folks that there's nothing inherently good about a lawsuit and that you're in a lawsuit when you have no other alternative. So 15-A-5 will allow the local governments, or will allow the governments and the individual to try to work things out before a lawsuit is filed. 15A-4 will come in after that time period is passed and that they can't reach an agreement, in which I do outline the remedies that you discussed earlier, Mr. Chairman, or making sure that these remedies are expressly recognized. Underneath A, 1, 2, and 3, it sort of lays out the remedies that an individual who is aggrieved, who's gone through the process, tried to work with the government, can't get a resolution, and then has to file suit. I've also have language that's from a couple of states that deals with frivolous lawsuits. And as we all know who are lawyers, not everyone who goes to court for good reasons. And there ought to be some type of sanctions for someone who uses this new law for either a frivolous or fraudulent reasons, and I have set forth sanctions for that. Regarding the bill as written also does not, moving on to 15A-6, the bill also does not set up any kind of statute of limitations. And I think that someone should not be sitting on their rights. If they've been aggrieved, if their religious freedoms have been restricted unfairly, that is something that they should be bringing fairly promptly to the government at issue, and so I put forth a 1-year statute of limitations. Other states have put that in as well. Whether or not it's 1 or more years, I think there ought to be some type of time period for that. 15A-7 deals with the issue of sovereign immunity. It's not specifically set out in the existing SB 129. I think it would be a good idea for us to clearly state that for very restricted reasons, sovereign immunity is going to be waived in this particular ways, but is not waived in others, and that's what A and B is designed to do. The heart of some of the changes that I want, in terms of, those are procedural changes that I think will make the bill work better in Georgia. In terms of the substantive changes that I would propose, Mr. Chairman, come in 15A-8, A of that provision really sort of lays out the law. The bill right now is silent as to what how subsequent laws will be handled, and this proposal will allow for that. And then you have the next provision dealing with civil rights. This is language from Texas, and I noted that Senator McCoon mentioned that Texas itself is considering changing that law. However, the original sponsor of that proposed removal of the anti-discrimination language has now withdrawn his support for that bill. In an article from the Houston Chronicle on March 9th, Republicans Representative Villalba, Villalba, after listening to various folks who were concerned with removal of the anti-discrimination language, decided that that wasn't in the best interests of Texas and has decided to withdraw his support for his amendment to that law. And so basically what I have here is a recognition that a law that everyone who's testified has stated this law should not ever be used for discriminatory purposes. We put it in the statute and recognize, however, there's certain exceptions for nonprofit groups such as churches who are carrying on religious activities, but for the ordinary activities of an individual in society, the civil rights laws that are in effect will be enforced. Real briefly, Mr. Chairman, in addition to that, you will find my last exception, number 3, found on the last page, deals with, and it states, allow any person to cause physical injury to another person. These are exceptions. To fail to provide monetary support for a child or fail to provide health care for a child suffering from a life-threatening condition. These were changes that are contained in both Texas and Missouri law. I think that's a good exception. I've spent the last 31 years of my law practice at one level or another dealing with child abuse. I started off as a special assistant attorney general. Then, after I came back to Atlanta, I served as a guardian ad litem with dealing with these cases. And for 10 years in the General Assembly, we've worked very hard to make it easier for victims of abuse to have their day in court. And I don't want to see a law now be wrongfully used. And I totally agree. Senator McCoon never intends for this to happen. But as he stated, bright lines are a good thing. And keeping this type of argument out of court will be a great help to someone who's being abused. It's a simple amendment, and I would ask for you to consider it, as well as a civil rights amendment that I've already.
Thank you. Just a couple of thoughts I had, just playing devil's advocate with you for a moment, right? The idea of the position on frivolous litigation, are we putting a chilling effect upon someone who may have a valid issue with whether or not a certainly a good question to be raised by that person, whether what is being done by a local or state government is actually an infringement upon their ability to freely exercise their religious beliefs?
I don't believe so. I believe that the standard for frivolous and fraudulent is relatively high here in Georgia, as defined, as I have defined it. The fact of the matter is, and I do have examples that I could give you, in which individuals, in my own personal law practice, have filed cases in which I had one actually filed claiming that he was God and wanted to sue all the churches because they were misusing his name. And this was a serial filer in which he kept filing, kept basically choking the courts over and over and over again. At some point, the courts have to have a remedy to deal with those kind of individuals. They're rare, but they do exist, and they do choke the court system.
And one other point I would wonder as we speak, and that is the statute of limitation. If you have something that's a statute or ordinance or position taken by government that is, in fact, this infringement that we talk about, if the year runs by, does that mean that now becomes legal?
What it means, keep in mind, Mr. Chairman, that it's an individual who must bring that claim.
Well,
and it must be the individual who's been aggrieved or who has had their constitutional rights.
Does it make it right even to that individual if it's a wrong intrusion?
I believe, Mr. Chairman, that a fundamental principle of law is you should not sit on your rights.
Thank you. I think first with you, Mr. Bruce.
Hi there.
Good to see you again.
Yeah. You know, I told somebody you and I worked on some things together. They didn't believe me, but
some of our best legislation together.
But you know, help me with this, because I know that the First Amendment deals with freedom of religion.
Yes, sir.
I'm not sure if it's written anywhere about the separation of church and state. I know that is a concept that people have believed and followed, and obviously the country has abided by that. Mm-hmm. Is that a correct statement?
Yeah, it's not. It's nowhere in the Constitution.
Okay. So, but as such, if that is a standard that we have gone by, that there's a separation of church and state, does not this bill in and of itself try to tell the state how it should interact with religion?
No, I don't believe so.
And in conflict with that concept.
It's a good question, but no, I don't believe so. What it does, and I don't believe that this bill creates any additional rights other than folks already have underneath the First Amendment to the Constitution and underneath the Georgia Constitution. However, what this bill does, in my opinion, is it basically sets out a roadmap for the courts and for government to ensure that those rights that are preserved underneath our Constitution are adhered to, and provides a remedy, a specific roadmap for remedies for individuals who believe that their religious rights are being infringed upon. In other words, we're not expanding anyone's rights. We're simply giving them an avenue for how they will advocate for those rights.
Okay, what it sounded like you just said is that we need a state law to enforce the federal law. That's what it sounded like you just said.
No, it's not well, what we need is a state law, because what's happened is, and Senator McCoon mentioned it earlier, we had a federal decision, was it Senator McCoon, 1990?
That's right.
1990, a Supreme Court decision that changed the standard of review for religious liberty, religious freedom. We then had a federal law passed in 1993 to address it. They thought at the time that would apply to both states, federal government, and the states. However, in 1997, was it? I'm doing good on guesses. In 1997, we had a subsequent Supreme Court decision that said the federal RFRA is fine for federal government, but doesn't apply to local governments. That's when you had all these other states, 19 of them have done it in statute, and some have done it by court decisions, have then had to go back and do it. Like I said earlier, the key to this bill, I think, is a good one. We just simply need to make sure that we have the anti-discrimination provisions in there that I proposed, as well as a provision protecting folks who are the victims of violence.
Thank you. Thank you. Mr. Fleming.
Representative Lindsay, I appreciate you coming today.
Yeah.
I was trying to look at and absorb how much of what you've given us, which is a lot. I see some of the places, maybe not most, but several places you've referenced another state.
Yeah.
Here's my general
before to sort of help you out here, if you don't see a change source, it's simply it hasn't been changed from SB 129.
Even if it's in red.
If it's in red, it's changed. The red are the changes, and hopefully at the top or at the bottom of the statute, I'll reference the states.
I'm trying to think where I've seen this, putting things in red before that you said. It's vaguely familiar, but anyway, I can't absorb it all right now, but I'm looking on your last page, right before Section 3. you have a clause that you touched on, allow any person to. These are things you can't do.
Yeah.
If you can't cause physical harm, can't fail to provide monetary support, can't fail to provide a child health care, or can't allow a child suffering from life-threatening conditions to go without treatment. So my question for you is, every time you put something else new into the law, new words, you give an opportunity for it to be interpreted differently. So when you put words into law, you want to have a real good reason. Mm-hmm. Is there anywhere where RFRA law has been held by a court to in any way say that you can't give a child health care, for example, or keep a child from suffering from a life-threatening condition?
Use the mic.
Fair enough. First off, let me sort of make sure you understand. We're already putting other changes, exceptions in that have never been in the other state as well. Penal, dealing with penal institutions as well as employers. So we're already going down that slope. First off,
where in the senator's bill does he do that besides the penal part?
Basically it says the exceptions are create any rights by an employee against an employer if such employer is not the government.
That's in two places?
Yeah.
Okay.
Well, that's in one place and then the penal in another.
Okay.
Here's my concern. This bill will be interpreted in brand new jurisdiction of Georgia. I have dealt with the issue, in particular dealing with child abuse and family violence for, like I said, over 31 years in one fashion or another. I've seen these arguments raised before.
Successfully?
No. But here's my point, and you and I actually had a back and forth on this by email earlier. The fact that it's not successful is not the issue. What I want to see done is I want to see the door closed. I don't want to see the arguments raised at all. I want to see that bright line that Senator McCoon accurately was concerned about to be laid out so that we don't have someone saying, well, I know this argument failed before, but now we have RFRA here, so now I'm going to try to raise it again. That does two things. Number one, it requires cases to go through the Court of Appeals and take time to be interpreted, and hopefully will be interpreted as you and I believe it should be, in which it would not be applicable. The second thing is that the victim has got to sit through the courts and listen to this, and listen to these arguments of religious liberty justifying their horrible acts. I don't want to make that more difficult on that victim when a simple language in the bill can provide a bright line that says you can't cross it, courts, don't even try to go there. We've spent 10 years, at least 10 years, because I've been here for 10 years, making it easier for victims to bring these sort of actions into court and to stand up in court and fight against these actions. I don't want to see anything done that starts to back away from the progress that you and I have done. That's number one. Number two, as you and I have a lot of experience, sometimes courts do things that we don't expect. And I'll give you two examples, one against you and one against me. Not against, but dealing with one bill that you carried. SB 3 was your
Senate bill?
Yeah.
Okay.
You carried the tort reform bill in the Georgia House.
Right.
A bill that would have provided caps for certain damages. I will tell you right now, neither you nor I thought for one moment that the Supreme Court would strike that down. They did.
I thought they might actually, but go ahead.
Well, I didn't. Secondly, was the charter school bill that I helped work on with Representative Jones. Both of us worked very closely with how other states had passed similar laws. They had been upheld. We believed it to be constitutional. The Supreme Court in Georgia struck that down. So the courts can do things that we don't anticipate. I have a proposed amendment here that closes that door, that takes away that uncertainty, that helps protect the most vulnerable people in our society. And while we're protecting businesses and while we are dealing with people in prison, I think we ought to take a moment and also protect the weakest among us.
So you don't think by putting something in the statute, which no RFRA law has ever been interpreted before to be a defense of the list of horribles you have, and nobody's ever gotten away with this, that you think it's necessary for us to do it in Georgia, even though it's done nowhere else and not been successful anywhere else?
I think I've just finished outlining my reasons why I think it's so important that we do so.
All right.
Thank you.
Yes, sir. Mr. Powell.
Thank you, Mr. Chairman. Let me ask you about some specific language that you've got in here. Looking on page 2, down at the bottom, where you define substantially burden.
Yeah.
I think I would take issue with you on that definition. I think burden means to inhibit or curtail. Substantially would be something beyond that. And so, I just toss that out for your comment on that.
Good point. And like I sat in this committee for a number of years, and not everything that I think of is right, and I think perhaps you need to tighten that definition further.
Okay. All right. Then my second point is actually really a question, and I'm looking at your 50-15A-8.
Yeah.
Subparagraph A. Explain to me what it means when you say, unless a state law passed by the Georgia General Assembly explicitly excludes application by reference to this chapter. Are we saying that this chapter is going to be the law in the state of Georgia unless we say it's not?
Well, that would be the law. That would be in any case. What I'm trying to make it very clear is actually just, I'm not creating an easy exception. I'm actually doing just the opposite. I'm making it very clear that just because there's a bill that passes after this bill passes doesn't mean that the law won't apply to it. I'm making it very clear that the only way that you're going to come up with an exception to this RFRA is you got to expressly state it.
But I guess my question is, does that not, I mean, if we're saying that if it substantially inhibits and that is not going to be allowed unless there's a compelling state interest, but then we say, but we can avoid even the compelling state interest test if we specifically say that we want to avoid the compelling state interest. I
understand the concern. The problem is that you've got a statute, and a statute can always be amended later, can always be changed later. You know, if you were to try to put this in the Constitution, that would be different. But since this is a mere statute, any subsequent bill could come along and try to amend it or try to amend a law. What I'm simply trying to put in here, and this is the best way that I came up with, and perhaps you can come up with a better one, is make it very clear that simply passing a subsequent law in and of itself won't do it. You have got to expressly refer to RFRA before you can do so. That's the best I could come up with.
Yeah, I think I understand now what you're attempting to do. I don't know that that I particularly like this. Let me ask you.
And like I said, if you can come up with a better way to guarantee that, all the better.
All right. My next question is that dealing with the next subparagraph A, the second subparagraph.
Sorry, that's my should be B.
In regards to the civil rights of individuals, is that a term that is so common that we would know what civil rights we're talking about, or does that need a definition?
I believe it should be easily interpreted, but if the committee in its infinite wisdom thinks it needs an...
I'm just asking.
No, I'm not being facetious either. I think it is, but if you think it needs to be defined, I think that would be...
Don't we have a statute that defines what are the protected rights?
I believe we do.
Classifications?
I believe we do. And if you might want to refer to a specific statute on that.
Okay.
Thank you.
And then the next one was just on the next page. I think when you took this from Texas or wherever it came, in section capital B, second line, nothing in section 1.302. That's probably a scrivener's error.
Sorry.
Yeah, I'm just asking. Is that what that is? Okay.
Yeah, that's all it is.
Thank you, Mr. Chairman.
Thank you. And we appreciate your being with us today.
Well, thank
Mr.
you very
Lindsay.
much.
Always good to see you again.
It's a joy to be back. To the minority on this bill, I ask you to work with the majority. To the majority, you've got the burden of governing. Please make it a good one. Thank you, Mr.
Who would like to speak next? If I can, I'm gonna do got a lot on this side, one on that side, two on that side. Let's start over here, first row. I'm gonna start on my left, your right. Who would like to speak next? Coming first, front row. You want to speak? Please come forward. And identify yourself and if you're representing a group. No, that mic over there to the left, you need to pull that one around. I'm more concerned about that because people are hearing us outside this room.
My name is Michael Bernstein. I am the rabbi of Congregation Gesher LaTorah in Alpharetta, and I'm speaking in opposition to this bill. And I come here as a person of faith, especially in looking at the Jewish people in the state of Georgia who, although we certainly have faced faith-based discrimination and still can experience the hurt of bigotry. We do believe that we are a part of the fabric of faith in Georgia, but there is not a single rabbi, a single voice speaking on behalf of our own Jewish communities in Georgia who supports this bill. And the opposite. There are rabbis from the Reform movement, the Conservative movement, and the Orthodox movement, which is an entire spectrum of our people. And I wanted to come to say the reason for me is simple. We have learned well as a minority that we can only have true religious freedom when all citizens are guaranteed dignity. My experience coming to Alpharetta as a Jew from the Northeast has been a pleasant surprise in realizing that all of my neighbors of diverse faith, which includes many biblical Christians and some of the largest churches and most influential churches, rather than feel in any way marginalized, I have felt that we have a great fellowship and we learn from each other. It's one of my great joys to come together with people of different beliefs and convictions. But because I am a strong believer that faith doesn't belong only in a church or only in a synagogue or behind closed walls, I believe that the only way to have that fellowship is to be in a society where no religion is more established than any other. And for that, no person's beliefs can trump another person's dignity. Every person has a right to be treated fairly in this society, whether by doctors or teachers, the local pharmacy, a court of law. But this bill does not protect these rights. It threatens them, and therefore it threatens the power of faith to bring us together. It makes faith into something divisive. It limits what we can get done. I believe that in this chamber and in this state, speaking on behalf of all citizens, when faith speaks to us, it should be to inspire our best, to remind us that the dignity of each human being should be held at a premium, and to ensure that no harm comes to the rights of any Georgian, whatever they believe and whatever they practice, whomever they love and however they live. A teaching in my own tradition teaches that it is a miracle that God creates each person out of the same image of God, which we call Tselem Elohim. But unlike coins that are pressed in the same press, instead of looking alike, we are completely different. And personally and deeply, I believe that God is diminished when we impose upon this diversity our own limited mold. If we pass this divisive and unnecessary legislation, we are choosing one narrow vision over the limitless possibilities of what can be accomplished when we act in good faith.
Thank you, Rabbi. We appreciate your being here today to speak to us. Did you want to ask a question, Mr. Fleming?
Please.
Thank you.
Rabbi, thank you for coming today. You just mentioned if we pass this bill, we're going to choose one narrow vision. Tell me what that one narrow vision is.
What I believe is that when this bill comes forward, it gives the opportunity for people to not only practice their faith, but to do so in a way that gives them the opportunity to limit the rights of other people that they disagree with. Now, speaking as a citizen, I think that's enough reason not to pass it. I don't feel that this bill leaves Georgians protected. But speaking of a person of faith, which I admit is simply out of my own personal belief, I think it does a double damage to us, because I think so much more can happen when we realize that as deeply as I hold my own faith, whether it's being Jewish or being Christian or a certain kind of way in which I interpret Scripture, I don't want to have other people shut out because they disagree with me or I disagree with them, and to make my actions hold them back or do harm to them in terms of their own rights.
Last question. This law is enacted in 31 other states and the federal government. Is there any place where what you're claiming might happen has happened?
Well, even more so than a lawyer, I don't feel that in a matter of faith that is about bringing the case law. What I think is that this statement, and not the federal RFRA, which was done to balance the real needs of one person's personal faith so that it cannot be trampled by the government, with the real needs of the rights of every citizen. But these kinds of state laws send a message that says that we are going to value a person who is going to say that their faith allows them to deny service to another, to make their lives less whole, and to deny them dignity. So I do believe that those things have been sent as messages. That's why in Arizona it wasn't signed when the bill came to the governor's desk. I think that other states have learned that in order to do a bill like this, you are standing on a side of history that says we are empowering people who simply don't want to see others that they disagree with have full rights.
You just have no example of that ever happening anywhere else.
I'm going to leave that to others in terms of the examples. Examples I give are the other state laws and what the message that they send, and the fact that the Jewish community is consistent and standing with many members of faith in each of these places in saying, we, as people who are minorities and need our religious faith protected, do not support these state RFRA bills.
Thank you.
Appreciate you being here with us,
Thank
Rabbi.
you.
On the first row, yes, sir. Next.
Mr. Chairman, honorable members of the committee, thank you for the opportunity to testify today. My name is Anthony Michael Kreis. I teach at the University of Georgia School of Public and International Affairs. I research in the intersection of LGBT rights and religious liberty, and I've been published extensively in law journals on the subject. I'm here to testify today in my individual capacity and do not represent any position of the university. First and foremost, I value religious liberty. I have publicly and often supported robust protections for religious minorities and religious objectors. I support the principles undergirding the Federal Religious Freedom Restoration Act, and I've worked to balance religious liberty and state rights, civil rights legislation across the country. SB 129, as currently written, however, fails to achieve an adequate balance. Direly needed, yet modest protections have been secured in discrete municipalities in Georgia against LGBT discrimination in housing, public accommodations, and employment. My largest concern about this bill is that it will permit free exercise challenges to civil rights laws and ordinances. The public is told that this legislation will not undercut non-discrimination norms, and I have no reason to doubt the sincerity of Senator McCoon or others who make those assurances. But a number of grassroots supporters have explicitly stated that goal while claiming to have no invidious interests. In short, their definition of discrimination is fundamentally different than most Georgians. For some proponents, denying services, housing, or employment on the basis of, say, race or sex is indeed wrongful discrimination, but mistreating gays and lesbians in the public square is not. If there was any doubt to the veracity of that observation, I suggest that the intense opposition to any amendment that would remove civil rights laws from RFRA's application speaks for itself. I believe that non-discrimination claim or any challenge to non-discrimination laws under RFRA will not really are unlikely to succeed. But it is an open question whether the state courts of Georgia would agree, and specifically there's no guarantee that the state courts in Georgia would consider local government interests in enacting non-discrimination protections as satisfying the tests set forth in RFRA. Now, I have great faith in our judges in Georgia, but LGBT Southerners are understandably skeptical. We cannot take for granted that our state courts will always mete out justice in our favor, as the Alabama Supreme Court has recently reminded us. Even if the ultimate conclusion of RFRA litigation arising from LGBT civil rights enforcement is resolved in municipalities' favor, it will have been achieved at considerable taxpayer expense. In that vein, there is a real, non-hyperbolic danger that the threat of costly litigation alone may deter municipalities from expanding non-discrimination protections, and that alone is a risk we cannot take. SB 129 includes language that seeks to assuage these concerns in legislative findings. But as we all know, these are merely a gesture. It is a fundamental principle of statutory interpretation that legislative findings have no robust legal operation. The vagueness in that language is complicated further when read against Georgia law more broadly. Georgia is one of only 3 states that does not prohibit private employment discrimination on any basis, including race and sex. It is one of only 5 states without any public accommodations law. Given Georgia's thin statewide civil rights law, how courts might use SB 129's legislative findings is unclear. At a minimum, I suggest that the bill should be amended to exempt civil rights law. Texas is a great example, but there is a particular problem with Texas's language, and I would refer you to Missouri as a better example. Missouri statute specifically takes into account the fact that many protections are in municipal law. My understanding from the top of my head, I don't have it in front of me, but Texas's civil rights exemption does not exempt local non-discrimination laws. So therefore, under Georgia, most folks would it would render that civil rights exemption fairly meaningless if it only applied to state statute. We must not jeopardize civil rights law, discourage municipalities from expanding non-discrimination protections, or otherwise embolden anti-gay animus. I urge you to reconsider this legislation in its current form and find ways to work together to advance the civil rights of all Georgians. And I'm happy to take your questions.
Thank you, sir. Don't seem to have any questions, but I appreciate you being with us today.
Thank you very much.
Coming further across the front row, is there anyone on the front row? If not, we'll go to the second row, starting on your right, coming across. Who? You're next. Come forward. Thank you.
How are y'all?
Fine.
I'm Merwin Peak. I'm Alan Peak's big brother. Y'all might know about him. He's the one with the hair and up there, but I got the looks, so that's good, But anyway,
he was out.
So anyway, thank you for letting me provide my thoughts regarding this Religious Freedom Act that the legislature is considering right now. First of all, I believe, first and foremost, that our Constitution allows for anyone to be able to practice their faith, no matter what that faith may be, without any interference from the government. When I was discussing the reasons why this bill is even being considered with one of the sponsors of the bill, and that is my brother, Alan, he gave me an example of why this bill was needed. We had this conversation last night as he was driving home from the medical marijuana legislation that he's working on. He said, let's talk about what could happen if a gay couple wants to go to a bakery here in Georgia and ask that bakery owner to create a wedding cake for them that has two men on the top of the cake instead of a man and a woman on the top of the cake. If that bakery owner has a religious objection to gay marriage, he should be able to refuse service to those individuals on that basis. He said this law would protect that bakery owner if that were the case. However, in the very next comment that we talked about, he said, with a gay couple, there's a simple solution here. He could just go to another bakery and have their cake made, and that would be the end of it, and everybody would be happy. Okay? I don't know about y'all, but I have an iPhone and an iPad, and I love my iPhone. And just a couple of months ago, Tim Cook, who's the CEO of Apple Computer, just recently came out as a gay man. And he said, and I'm quoting him, this is the CEO of Apple Computer, "Throughout my professional life, I've tried to maintain a level of privacy. I come from humble roots, and I don't seek to draw attention to myself. Apple is already one of the most closely watched companies in the world. And I like keeping the focus on our products and incredible things our customers achieve with them. The company I work for has long advocated for human rights and equality for all. Apple Computer has 50,000 employees. And in 2014, they declared over $171 billion in revenue. It is by far the most valuable company in the world."
Let's people will run out of time in a minute. I want you to get to the issue if you have one regarding the bill.
Okay.
Speak on that for me,
well,
if you would.
I'm getting to it. I promise.
All right,
I promise. It's coming. Okay.
Please do.
I would hate to see a company like Apple decide to not move employees to Georgia just because they think that their employees are going to feel uncomfortable. They feel like they're going to be discriminated against. And I'm a recruiter. I'm a corporate recruiter here in Atlanta. And I recruit very high-paying technology jobs. And Apple's an extremely attractive company to work for. These people buy houses, they buy cars. And I think essentially a bill like this would give people the license to discriminate because of their own religious beliefs and make companies like Apple, who embrace diversity, think twice about moving here. I think it's an economic thing. I think the best companies in Atlanta, Coca-Cola, AT&T, all have diversity and inclusion as part of their culture. And those companies are going to take pause if they think that there's a state law that may allow any of their employees to be discriminated against. And that's why I'm here. I'm seeing an impact on that. So I think that's why this bill is bad for Georgia. And that's if anybody has any thoughts about that, I'm happy.
We appreciate you being there. I've been asked to recognize Gary Weber.
Mm-hmm.
Jerry, you here? There you are. Come on up here. He's going to speak. I just one of the committee members.
You want me to stay here?
No, sir. You're all right.
Oh,
Thank
okay,
you.
good.
Thank you a lot, Mr. Pete. Come in.
Thank you, Mr. Chairman.
All right.
My name is Jerry Weber, and I speak on my own behalf. I've been a constitutional attorney for about 20 years, and I'm in opposition to this legislation, even though I generally do religious freedom cases. I have done cases for plaintiffs, for ministers, for pastors, for religious groups under the Religious Land Use and Institutionalized Persons Act, the Free Exercise Clause, RFRA. I've represented a Baptist minister in Warner Robins who sought to protest. I represented a Baptist church in East Point who sought to locate downtown. I am opposed to this legislation for two reasons, and primarily I want to focus on the second, given the questions that have been raised. First, I don't believe that this bill is necessary. I've looked at the 22 cases listed. I've analyzed each of them, the 22 cases that supposedly say that this legislation is necessary. All of those cases prevailed under other provisions, whether it's the freedom of speech provision, the federal RFRA, the Equal Access Act. All of those cases won, except one individual who sought to proselytize on a university campus but didn't even seek the permit that was required from that university. So I don't believe that the legislation is necessary, but the second reason is that I have seen how states have interpreted the federal and state RFRA to create problems. And I want to point to 5 cases. I've got a dozen decisions here, but I'm going to point to 5, and I'll talk about them very quickly. One is a United States Supreme Court decision from 2005, Gonzalez, 126 Supreme Court 1211. There, a religious group sought to be exempt from the Controlled Substances Act, the primary anti-drug act of the federal government. They sought to use ayahuasca, a hallucinogenic tea. And the Supreme Court said, yes, you can. You can use that hallucinogenic tea. Now that decision, because RFRA only applies to the federal government, does not apply here. Once this legislation passes, it applies here. Second case, Dallas. The case of Big Heart Ministries versus City of Dallas. A religious group sought an exemption to food safety criteria and location restrictions. Essentially, food safety criteria, they said, didn't apply to them. They used Texas's RFRA. They won, and the City of Dallas paid more than $1 million in attorney's fees. Anti-discrimination laws. The Second Circuit held in 2006 that the RFRA trumped the age discrimination law. Anti-discrimination laws may fall based on this legislation. Refusing to provide medical services to patients. The 11th Circuit thankfully held that RFRA did not allow that, but the case went all the way up to the 11th Circuit in 2012. I have a dozen cases here. I can give them all to you. But the fact remains that some of these cases win, some of them lose, but all have led to persons asserting a veto power to criminal laws, to health and safety laws, to anti-discrimination laws, to child welfare and child abuse laws. 3 miles away from here, in 2005, Pastor Arthur Allen in the House of Prayer Church claimed, and this is the ABC News national headline, police call it abuse, pastor calls it God's will. And he directed that 41 children be beaten by congregation members. Do we want to open the door to him asserting a religious right to do that? I believe not. Thank you.
Wait a minute, yes. The point Who's got, that's yours, Ms. Buskin? Please.
Thank you, Mr. Weber. Your first example of unintended consequences or likely results, you mentioned the case where, the Gonzalez case, where RFRA was used to justify the use of hallucinogenic tea.
That's correct.
But that's kind of how this whole thing started. I was in law school from 1986 to 1989, and at that point, Native Americans had the right to smoke peyote because they did have a sincerely held religious belief to engage in that practice. And then, I guess in 1990 or so, the Supreme Court said no, and that's what started the whole impetus behind RFRA. So not everybody would be allowed to smoke hallucinogenic tea, but truly under this bill, if you had a sincerely held religious belief and that was part of your religious practice, that's really what this bill is for. So I would love to see your cases, and we've been asking all afternoon for cases, and you seem to be the first person who came with any, so I really would like to see them, but some I think really are a justification for this bill rather than a reason not to pass it.
Sure, and let me speak to the sincerely held religious belief.
Okay.
And give you one example. Ballard versus United States, a United States Supreme Court case, 322 U.S. 78. There, the Supreme Court held that a man who had a self-styled religion called the I Am religion, where he was the only person who had a direct line to God, could have an exemption to a mail fraud charge. And the Supreme Court said, and courts uniformly say this, is we don't get into the business of questioning whether a relief is sincerely held or not. And so they recognized that he had that exemption to the mail fraud charge. So one could imagine an I Am religion asserting the right to smoke a drug and saying, look, Ballard says I can have an I Am religion, I've got a new one, and I get to smoke a drug. And certainly that is a possibility. Now, would it be successful under this, if it was litigated? I don't know. But it would certainly be a strong argument.
Well, I agree with your point there, and in the bill that we're looking at, and I think Mr. Bowers pointed out, the definition of exercise of religion means exercise of religion, and that doesn't give us a whole lot of guidance. Whereas some state RFRAs have a different definition. For example, Texas, free exercise of religion means an act or refusal to act that is substantially motivated by sincere religious belief. So if we had a definition more like that, a judge would be required to ask whether someone had a sincerely held religious belief, but it might be a weird one, and they might be the only person who adheres to that religion, or their religion might be Satan worshiping, or their religion might be agnosticism or something. But I think if the impetus of this bill is to protect people's faith, which is something we can't see or measure, you're going to get into an area where it's not objective.
Well, even those states that have attempted to define sincerely held religious belief kind of fall back to the presumption that it's very difficult to say what one's religion is and what's not.
Right, and I think I agree. Thank you.
Religion is sort of a conscious belief, is it?
Absolutely. Yes.
So I mean, if I say I've got a conscious belief in something, whatever that may be, that's my religion.
Yes, and I am representing a client right now who has a belief that he is a Christian vegetarian, and we've got a case in federal court right now because it is his belief.
All right. Ms. Oliver?
There was a recent Pew poll, survey, scientific right or not, but it said, and I was surprised, that 20% of the population do not express a faith. Does this bill address that issue? And the hypothetical I'm looking at is the manager, the boss,
right,
asking a group of coworkers to pray with him every morning prior to work. Does that bill protect him?
This bill?
This bill, excuse me. Yes, sir.
As it's written, probably not, because it only protects religious practices, and if one has a lack of religious practice or a lack of religious belief, they could not claim this.
It's also the government compelled this to be a practice. I mean, what's going on, I guess I'm reading the bill, is what's in the private sector is not one that would be an issue of this bill. It's only if there's a law, ordinance, rule, regulation of a government body that says this is what you can and cannot do that may be infringing upon that practice?
There's one exception to that, and I think that
Okay,
that's
that's good.
generally true. But if you look at the language,
That's the one I want to hear about.
any other state or local public instrumentality or corporation or any other person acting under color of law.
What line are you reading?
It's 82 and 83 on my version. It's on definition 4.
Is that what government means?
That extends the definition beyond governments to private corporations as defendants. And in fact, RFRA and 42 U.S.C. 1983, which is the vehicle for suing for constitutional violations, have...
I think, I appreciate you pointing out, but that is reading as to a public corporation.
Right.
So if the corporation was set up as a public body, meaning not one that is a private corporation, but a public, I think of authorities being a form of, but we don't call them corporations. And it may be somebody could try to take that language and push it that way. We don't know.
Yeah, and actually the other person acting under color of law is really where corporations have been found to be defendants. Under RFRA, there are the Sixth Circuit, the Ninth Circuit, and the Seventh Circuit have found that private corporations can be sued under RFRA.
Acting under color of law.
And 1983, actually, the Supreme Court has a decision called Lugar, 457 U.S. 992, that said that private defendants can be sued if they are acting under color of law, because it was an interpretation of that language. The Ninth Circuit case that found that RFRA applies to private corporations and allows them to be sued under federal RFRA is 192 Fed 3rd 826. So there's 3 circuits that have said under RFRA a private corporation can be sued using language like this, other person acting under color of law. So there's a lot of exposure for corporations.
That's a good point. Thank you. Any other questions of Mr. Weber? We appreciate your coming down and seeing us today. We've got, we're now at 5:05, which really is coming to the end of time. I realize there's others who would like to speak. I'm going to give one more person to decide who wants to come up, because we're really we're almost out of time.
Mr. Chairman, excuse me, we have one of our members from the hotel industry who's been here all day.
All right.
Ron Tarson. He's a proponent. I'm sorry.
Okay. There's one other person can speak, and then we're going to bring the public hearing portion of this matter to a conclusion. Please give us your name and who you represent.
Thank you. My name is Ron Tarson. I represent the
Tarson,
T-A-R-S-O-N.
Excuse me.
I'm the chair of the Government Affairs Committee for the Georgia Hotel and Lodging Association.
Yes, sir.
We represent about 2,000 hotels and related lodging properties throughout Georgia.
You speaking for your organization?
Yes, sir.
All right.
And we're very concerned about the proposed legislation that creates a perception that Georgia allows discrimination. Let there be no mistake about our position on religious freedom, however. We're 100% in support of religious freedom as outlined and protected in the Constitution of the United States and the Constitution of Georgia. However, we believe that this legislation is unnecessary and that sufficient legal protections are already in place. We oppose the legislation because diversity is at the heart of our industry, and our world-renowned Southern charm and hospitality is critical to keeping Georgia a great place to visit and to conduct business. Georgia's reputation as an open and welcoming destination must remain clear and present in the minds of our guests and the people who choose to travel and conduct business in our state. Our customers, the vast majority of whom are from outside of Georgia, are concerned. This isn't an exact copy of RFRA, as has been pointed out by others that you just heard. And a key to it that our customers have noticed is the inclusion of lines 18 and 19, making specific reference to the more protective language of the state constitution of Georgia. Our customers are questioning whether this creates a friendly environment, and it's making them reevaluate whether they want to come to Georgia and do business. In the last 2 days, the Atlanta hotel community has received notices from 2 large groups that intend to withdraw their consideration for conventions in Georgia. One of the groups is the American Society for Higher Education, which has a November 2017 conference of 1,900 people withdrawing their interest, and the other one is the American Studies Association, which is suspending its bid to hold the 2018 annual meeting in Boston. They state that in response to Georgia legislature's consideration of the Religious Freedom Restoration Act, the American Studies Association is suspending its bid for our annual conference. Should the legislation pass, the ASA will not meet in Georgia. Georgia's Senate Bill 129 would allow individuals and corporations to discriminate against marginalized groups on the basis of religious belief. It goes on with some detail, but I just want to point out that those two notifications came as the bill was being considered, and we know that if this bill is passed, we can count on many more, which will have a very negative impact for the lodging.
Thank you. Any questions, Mr. Tarson? Yes.
One, Mr. Tarson. Thank you. You mentioned the American Studies Association has given a notice of intent not to come. What did you say about Boston? Is that where they're based, or that's where they're going?
No,
you said something about Massachusetts right after that?
I don't think I did. Oh, I did.
Okay, because I was going to point out, I mean, it's true people have talked here today. 19 states have RFRAs and 32 if you consider statutes. So that there are few. I mean, there are more states in which that have RFRA that are great places for conventions than.
Honestly, one of the things they zero in on is the lines 18 and 19, especially the licentious behavior portion of that, and that worries them.
Okay, thank you.
Anything further, Mr. Parsons?
Thank you.
Thank you so much. We're going to now conclude public comments on the bill, and I appreciate everyone having spent the time with us this afternoon. We appreciate your input. We're going to adjourn at this time and consider coming back tomorrow afternoon. I'll notify by notice that event.